ನೀವು ಮೀಟಿಂಗ್ ಬಿಟ್ಟು ಹೋಗೋದು.
fresh matter. Or yeah. Yeah. Filing of application. Let it requisite application be filed within 2 weeks. This thereafter. New person. So much attached to this. Yes, sir. How you use date? He knows starting date in this. Date since he's 15%. Give a date. What date?
What is this?
7.
Yes, no, appellant wakalat not right.
Not that not that July is holiday and this court is going to be closed for remaining part. Why should you stop all the cases? Why also just do everything June? Why?
And it depends with how when he is going to appear before the committee and then get the certificate.
We have given 2 weeks time. Let it be. Thereafter, he is not bothered. We are not concerned about his case. July, 11 July. Based on 11 July 2022. Number 2, the not yet. 2 weeks time is granted to comply with office objection. Steps to be taken for unserved R1 to R3. Nobody is there. So what do you want? Let that be taken. Let office objection be complied with within 2 weeks. Line below. Issue notice of IA2 of 21 to the appellant as well as the respondent. Yes. Number 3, we are Rishi Kumar. 2 weeks time.
Appear for the appellant's minute.
2 weeks time. 2 weeks time is granted to comply with office objections. Write the whole thing. I'm just saying. 5. 2 weeks time is granted to comply with office objections. 6. In order. 8. The addition. Same order. Same order. Number 10.
My lord, serial number 11, I have already filed complaint. Only office objection is in the connected matters, name was not the number, our number was sure, but we have produced a memo in page 22. My name is also, our petition is also produced. And that is the only objection remained. I have filed objections to that also explained. Because other things are complied.
There are 2 office objections.
Copy of statement of objections, its verifying affidavit and its annexures
Are already
to be produced in both sets.
Sir, there is no, the only adoption memo is filed, that has been produced. Other connected matters, a joint order was passed. In connected matters has been filed, a joint memo is filed. Therefore, we have filed a separate rejoinder in both the cases. Explaining the same.
And one more office objection, sir. Annexure R3 pages to be stitched correctly in order from page number 43.
According to my collector, that I will do it. This objective may be overruled. They say unless there is order, they will not do it. That's the I only.
Weeks time. Oh, 2 weeks time. Appeal is not maintainable. Not properly this petition under section order passed on a petition under section 482 has been challenged. So what we think, is it maintainable? No, not passed. It is listed on maintainability of the petition. Right? No, nothing. You take this. Please see. There is nothing to be seen. Please see the impugned order. It's a order. Had it been a difficult thing, we would not have troubled you. It's simple, right? Petition under section 482. Order. Can a writ appeal like? Doesn't like. Right? That's the simple thing. Otherwise, we would not have troubled you. That's why we gave. What's your name? Learned counsel for the appellant. Learned counsel for the appellant. Cyril Pius. Right. Learned counsel for the appellant. Learned counsel for the appellant fairly submits that the writ appeal against the order dated 7/6/2021 is not maintainable as the same has been passed on petition under section 482 of the Code of Criminal Procedure. Full stop. In view of opposite submission and in view of the fact that no intra-court appeal lies against an order passed under section 482 of the Code of Criminal Procedure, the appeal is disposed of with the liberty to take recourse, liberty to the appellant to take recourse to such remedy as may be available to him in law. With the aforesaid liberty, the appeal is disposed of.
Number 13, Sri Gautam Desmudar.
2 weeks. 2 weeks time is granted to comply with office of.
My lord, 3 weeks, my lord, please, my lord.
3 weeks.
15 also, my lord. Serial number 15 also, my lord.
18 and 15 also. 3 weeks time.
Much obliged, my lord.
Adjudication.
She has short time already in 15 also. 3 weeks. 15 also she said.
Yes, my lord. Yes, my lord. 15 also, my lord.
14. What about 14?
14, I am not there, my lord. Different council.
Then why should you, jump the queue, right? 14, 2 weeks time.
Number 16.
15, 3 weeks time.
16, my lord, it is only, my lord, the writ appeal is filed against the cost imposed by the learned single judge, my lord. I am the caveator respondent. Since, my lord, December.
2 weeks time is granted by way of indulgence to comply with office objections.
17, Narayan Bhatia.
My lord, I pray for 3 weeks time, my lord. I do the next.
3 weeks time.
Please, my lord.
Granted to comply with office.
Much obliged.
18, Shivappa. 19, Sri Rukumar Rena.
Current counsel for the appellant submitted that a sum of rupees 10,000 towards litigation expenses have been deposited by the appellant today. Office to verify and proceed. Yes.
19, Sri Nagarajas.
My lord, there is an appeal against the orders passed in family court in section 17 of the Family Courts Act, my lord.
Family Court Act.
Family Courts Act, under section 17. And
Why-
because
why-
the case
what
was
is the
filed under
objection?
section 125, my lord. But when the case was pending, then I filed a writ petition and it was pending before this honorable court, and within the meantime they have passed the orders. And I am paying the maintenance regularly. In spite of that, they have passed the
It is
orders.
an order passed under 125, right?
Yeah, 125, my lord. Based on 125, my lord.
So
But,
section 19(2) Family
and,
Courts Act, you must have read it. Appeal does not lie.
No, my lord, that is no appeal lies shall lies the decree on the order passed by the family court with the consent of the parties. If the order was passed by the consent of the parties, it's not the consent of the parties. It is an order passed by the single judge in my absence, because I have not led the evidence. Finally, they have order passed on merits, my lord.
No,
Therefore,
that's the problem. Thereafter, you are not reading conveniently.
the 14.
From an order.
No, my lord.
Or from
4.
an order passed under chapter 9 of the
9, my
Code
lord.
of Criminal Procedure that you are not reading.
No, my lord.
And
This
you are
honorable
telling
court
us,
has got
"Oh, this
has
is
got a
Mr. Counsel, you have to be fair to the court. You cannot read only one portion of the statutory provision and omit to read the other one.
no, my lord.
It says, no, consent of the parties or from an order passed under chapter 9 of the Code
Yes,
of
my lord.
Criminal Procedure.
But
This is an order passed under chapter 9 of
but
5.
my lord, this 19.4 is applicable, my
This
lord.
appeal.
19.4 is applicable, my lord. The High Court may, on its own motion or otherwise, call for examine the records of proceedings.
Otherwise means you have to approach by way of a petition or whatever. We are not inclined to do exercise power suo moto. That is a suo motu revisional power. We are not sitting here to tell you what you should do. In this appeal filed under section 19 within bracket 1 of the Family Courts Act 1984, the appellant has assailed the validity of the order dated 19th March 2019, passed by the Family Court on a petition preferred by the respondent wife under section 125 of the Code of Criminal Procedure. Full stop. Line below. Section 19(2) of the Family Courts Act 1984 reads as under 92. Thus, line below, thus from perusal of aforesaid provision, it is evident that the appeal against an order passed under Chapter 9 of the Code of Criminal Procedure 1973 does not lie under Section 19 within bracket 1 of the Act. Full stop. In the instant case, the order admittedly has been passed on a petition under Section 125 of the CRPC. Therefore, in view of our contained in Section 19 within bracket 2 of the Family Courts Act 1984, the appeal does not lie. However, this line below, however, the same is disposed of with the liberty to take recourse to such remedy will be available to him in law.
Much obliged.
Alert for the petitioner in this moment. A week's time may be granted.
Number 23, Sri
2 weeks.
24, Sri Vivekananda.
2 weeks. Mr. Vivekananda TP Learned Council undertakes to comply with office objection in the next week. Comply with office objection whenever you want. Within 2 days, we will list it on Monday. 13th, list on 13th June 2020.
And IS number 25, Sri Nilin Rangan, government advocate.
Calling, yes, madam. When was it dismissed, Mr.
10th August 2017.
And when this application has been filed? Recall. Also,
8 September 2017.
immediately within 1 month. All right. Huh?
In 18 it is fine.
Huh?
18 it is fine.
18
IA 1 of 18.
September.
IA 1 of 18. Number is given as 18. If it is filed in
Yes, madam. All right. None for the applicant, learned additional government advocate for respondent. Peru IA number 22 as well as 1 of 18. Line below. For the reasons assigned in the application, duly supported by an affidavit, we find that sufficient cause for condonation of delay in filing the application for recall of the order dated 10/8/2017 is made out. Line below, accordingly, delay in filing the application for recall of the order dated 10/8/2017 is condoned if the result IA 1 of 2022 is allowed. Also, Peru IA number 1 of 2018 for the reasons assigned in the application, which is duly supported by an affidavit order dated 10. WA number 2332/2017 is restored to 5. In the result, IA 1 of 2018 is allowed.
26, Ramesh P. Kulkarni, Sri V. Ravindranath.
Memo of retirement. Who has filed? Mr. Devraj case, learned counsel has filed a memo seeking leave of the court to withdraw, to permit him to retire from the case. He is permitted to do so. So accordingly, memo is accepted. What state? What state, Mr. Hola? Huh? Huh. Oh. We'll list it for admission whenever you want. For stay today. We are hearing it on admission, not stay. Whenever next week, whenever you tell the date of your choice. Huh? He has to argue the appeal on admission. Just seeking his. You want the stay application to be decided, right? Yes.
If the application says further proceeding before assessment, that can be done.
All right. Heard on IA number 1 of 2022. After hearing learned senior counsel for the parties, it is directed that further proceedings pending before the assistant commissioner in pursuance of the order dated 6th of December 2019 passed by the learned senior judge shall remain stayed during the pendency of this appeal. Accordingly, IA 1 of 2020 is allowed. It will come up or you can mention. Yes.
77, the PD Surana.
Issue notice of IA number 1 of 2022 to respondent record.
78.
Order, right?
I appear for the petition, my lords, on the last occasion. My lords
28,
ordered delinking and permitted me to file an application for deletion of prayer A. That I am, my lords.
Item 28.
Yes, my lords.
28 is an IA for early hearing. What?
No, that has been allowed, my lords, long ago. Now, on the last occasion, my lords permitted me to file an IA for deletion of prayer A.
When it has been allowed?
That IA for early hearing has been allowed. My lords.
11-4. Not allowed. Matter, it is not allowed. Not allowed, Mr. In this case.
It was actually. My lords, what happened? Batch of matters were coming. It was in hearing list. Now, my lords, thereafter I requested for
deletion of prayer. Right. Any objection to that prayer? Any objection to the prayer? Deletion of prayer. Right. Which is the IA, Mr.
IA, my lords.
Petitioner. Oh, what is that IA? Where is that? Which IA number? 2 of 22. Not find it. Hey, not across the counter.
Sorry, my lords.
Please.
I got copy 3 days earlier, my lords, so I thought it is filed.
All right, let him file. Learned counsel for the applicant place for short accommodation in order to enable him to file an application seeking deletion of prayer as indicated in the order dated 30th May 2022. Let the appeal be listed for consideration of the aforesaid IA as well as IA for early hearing in the next week.
Great.
Yes.
Serial number 29, I'm appearing for the appellant, my lords. There's await notice for the R2, my lords. My lords, PS Mali Patil is appearing before the learned single judge, my lords. I may be permitted to take out note.
Wait, Just await service of notice on respondent number 2. In the meanwhile, learned counsel for the applicant is permitted to serve a copy of memo of appeal along with the research on Mr. Which count? Who?
PS
madam?
Mali Patil. PS Mali Patil.
Yes, Mali Patil, learned counsel who represented respondent number 2 in the writ petition.
Please, my lord.
Before the learned single judge.
Please, my lord.
What is over?
31.
Milord, I.
Right. Yes.
Milord, I appear for respondent number 1 and 3 in 31.1, Milord.
Yeah. So we'll fix the date whenever you want. Tell us. Madam, please.
Yes, Milord, I am fine, Milord. Milord,
It we might, right?
matter is pending before
your
honorable.
argument to her. Not the conduit like between.
SLP is pending, Milord, before Honorable Supreme Court on this ground, limitation ground. And on last bit of hearing, court adjourned the matter.
Then we should defer the hearing. Then you should say, you told us that it requires consideration. You should have told that it should be deferred. Right. Learned counsel for the parties jointly submit that the issue involved in this appeal is pending adjudication before the Supreme Court. But we have said the issue. Supposing if the SLP is decided by the Supreme Court, we are bound to follow that under Article 141.
In that case, Limitation Act will not apply.
That issue is pending. No, you are. No. So, are you saying that it's not pending? We will record your opposition also. You want us to write a long order for nothing, which is an unproductive thing. Eventually, the proceedings have to be deferred, but we will do it for your satisfaction. Right? So, for which 31. Yes, madam, you appear for any respondent in 31.
No, Milord, we have not received any notice from in this matter, and I am not aware about that matter.
Yeah. So you take notice for National Highway Authority.
Milord, in 31.1, I appear for National. 31, I don't know whether it is which matter. I am not aware, Milord.
Which case you are appearing? 31.1. Which respondent? That is 31.1 serial number. You want to make our life difficult. We are trying to do it simple. We are going by, you want to complicate. Tell you that it's 31.1. Which respondent you are appearing? Which case? 31.1 is for the apple. Say he is not appearing. What's your name? So 31.1 you are appearing MFA 7120. Are we required to tell you this also that you are appearing? You said you are not appearing. What that? For respondent number 2, madam, right?
Milord, I appear for 1 and 3, Milord. I appear.
Respondent number 1 and 3.
Yes, Milord. Respondent number 2, Milord, government advocate may appear.
Respondent number 2. And who is the appellant? You are appellant. So your submission is, madam, that its issue is pending before Supreme Court, right?
Yes, yes, Milord.
Therefore, hearing should be deferred.
Yes, Milord. Yes, Milord.
1.1, right, the order sheet. Mr. Raghavendra Vikar, K. Learned Counsel for the appellant. Mr. Shilpa Shah, 1.3, Learned Additional Government Advocate for Respondent number 2. Right. Counsel for Learned Counsel for Respondent number 3 at the outset submitted that the issue involved in this appeal is with regard to applicability of Limitation Act in the proceeding before the Deputy Commissioner under the National Highways Act. Full stop. It is further submitted that the aforesaid issue is pending adjudication before Supreme Court in a special leave petition arising from the judgment of the Kerala High Court. Full stop. You have the number, madam? No.
Yes, Milord. SLP number.
Namely SLP number, Kerala High
Zero-
Court, namely SLP number
06604
06604
of 2019.
2019 paragraph. On the other hand, Learned Counsel for the appellant has then say SLP number so and so, then it is therefore submitted that the hearing of this appeal be deferred. Paragraph. The aforesaid submission has been opposed by Learned Counsel for the appellant on the ground that no SLP has been preferred against the division bench decision of this court passed in which appeal? In WA number, WP number 31 by a division bench of this court. Paragraph. He is saying writ petition. It appeal. There will not be such numbers. There cannot be such number. 21,000. No, you have it, Mr. Are you sure? Writ appeal number 6.
It won't be 31,000 to be 1 lakh.
Find out.
Earlier there used to be such numbers. Afterwards, started with 2 lakh, 1 lakh.
Right. All right. So, paragraph. So no appeal has been preferred against order dated so and so, passed by division bench of this court, WP number so and so. It is therefore submitted. The appeal should be heard. Paragraph. We have considered the submission made by Learned Counsel for the appellant since the law which consideration in this appeal is pending consideration before the Supreme Court. Therefore, in the facts and circumstances of the case, we deem it appropriate to defer the hearing of this appeal as the law which may be declared by the Supreme Court finds this court under Article 141 of the Constitution of India. The submission made by Learned Counsel for the appellant is therefore rejected, and hearing of the appeal is deferred till the issue is adjudicated before the Supreme Court. The parties are granted the liberty to the matter. The appeal is SL satisfied. 31 list along with item 30. What is it? What is it? The notice has to be issued to the other side. 31 you write. 31 to be passed on IA1 of 2022 as be posted according to IA1 of 2022 is disposed of. Heard on the question of admission, issue notice on IA1 of 2021, right? List along with item number 31.1.
Obliged, Milord. Obliged.
Number 32, the Jairam case. finally issued notice. So what is the degree? You are required to tell us. Are we not supposed to ask you what is the degree against which you have filed an appeal? No, no question of senior. You see, from see this record, you at least tell us who has filed this appeal. How can respondent file an appellant is filed an appeal? Husband or wife? Husband has filed. What has happened? See the judgment and degree, madam. You are an advocate. No password right now. Only thing we are asking you, who had filed the petition, what happened to that petition, and you have told us husband has filed it. We want to know what happened to this judgment. So
You read the prayer.
Petition? Who filed the petition before the family court, madam? Petition before the family court. Who filed? Why filed? What petition she filed? What petition? Under which provision? What happened to that petition?
Come to the operative portion of the order, impugned order.
What happened to that petition?
In page 56.
Supposing, madam, it would have been dismissed, right? You would not have filed an appeal. Common sense is it has been allowed, right? That's why you are here. Read what madam is pointed out. Read page 56.
Page 56. In page 56.
The filed by wife has been. Yes, madam. What has been done by the family court? Allowed. And decree and the marriage has been dissolved, right? You are agreed. That's why you have filed an appeal. This you should tell us, no? The senior is not required to tell us this. Right? So why you shouldn't tell us this, that this appeal is by the husband and the petition filed by the wife under section 13 has been allowed and the decree of divorce has been. Oh, what's your name? Read counsel for the appellant. Two orders are required to be passed on IA 1 of 2021. Therefore, the same is dismissed. But on IA 1 of 2021, the appeal filed by the appellant is within limitation. Therefore, no orders are required to be passed on the IA. Accordingly, same is dismissed. Also, third, on the question of admission as well as IA 2 of 2021, issued notice. Office is directed to secure the record of the family court. Also heard on IA 2 of 2021. Getting learned counsel for the appellant, it is directed that operation and effect of the assumed judgment and decree insofar as it directs resolution of marriage shall remain. Fine. What order have we passed? Tell us. What order have we passed? What you are required to do after this, madam? You have to pay process fee. What has been done? Appeal has been admitted. And what orders have been passed on your application for stay? This issue, what else? Tell madam, tell her. She will explain. Please go to her. Please go. She will tell what order has been passed. What order you don't know? What will you tell your senior? What has been done? You tell. You ask her. She will tell. Right. Ah. Notice of IA 1 of 2020, of 2020, official directive, report of the family. Okay. It is barred by litigation. There is a this thing until unless delays control, it cannot be this thing granted. Supposing if it doesn't appear there, say that he has been served. Why the wife should not be husband, right? Why the husband should not be served? Marriage season otherwise is over, right? Till they on marriage season. What do you think that he will marry? Nothing happened. You should think. No, but we are telling you that if you serve a copy and it doesn't appear, we will not treat it to be a valid service. Fine. In addition, right? Issue emergent notice in addition. The appellant is permitted to serve a copy of the applications as well as memo of the counsel who represented the respondent in the proceeding to the family court. However, it is made clear that mere supply of copy to the counsel would not be deemed to be a valid service on the respondent. Before executing court, not family court. See, supposing if the counsel doesn't appear or wife comes, husband comes and says that I had never engaged, what will happen?
Admission. 34, the other year, going graduate.
Oh, all right. Is admitted. Why is this? The appeal has already been admitted for hearing on
24/5/2022.
24/5/2022. Let the same be listed for final hearing which day? All right. So we'll take it up after the motion hearing is. No. But time we can't fix. Whenever it comes. Whenever it comes in the second round, if you are not there, then we don't. If the Supreme Court has requested this court, you are also under an obligation to cooperate. All we are saying is that other motioning, supposing if you argue for 2 hours, everybody else will be kept waiting. We are simply asking for your cooperation by half an hour or whatever time we don't. Yes. Don't say. Have you prepared a synopsis or whatever?
Yes, sir.
No, nothing. He has given. Given.
35. Ismail Gupta, CH Gupta.
Last week, the copy will find the acknowledgement.
Just a minute.
Yes.
So you have filed the objection. 1 to 5. Let me hear him. All we asked was, are you ready? I mean, supposing if you would have argued thereafter, you would say, I need time to file objection. You are ready. You have filed the objection to this IA, etc. You don't want time. So whatever it is, I mean, you don't write. You don't want. Fine. Yes. That is really unknown to us, and with your experience and age at the bar, we believe that you have begun as a young. You began this practice of law at the age of say 27, 28 years, not after superannuation. So you know that it's his appeal. He has a right of audience first. He is for the appellant. It can't go reverse either way. That respondent should be heard first, and he has not uttered a single word.
Right of limitation cannot be waived. You know, waive that part. Right of limitation should not be waived.
Nobody is treating as waived.
Sometimes that happens with you like that. Law of limitation might be strong, law of limitation.
Have you filed any application, or you are orally raising? Or the appeal is barred by limitation. So, is it so? No, not so. It's only on admission, right? What is it?
The
Order?
is the government of India undertaking methods. They had an agreement which they responded to the transporter. The agreement methods, which is of the year 2008, had an arbitration clause. The arbitration clause is
against an order dated 22nd March 2019, right? So, who had filed the petition under section order? You had filed order 7.
filed an application under section 8 methods when the suit was filed.
Your order 7 rule 11.
There were 3 applications filed. One was order 7 rule 11, which is not subject matter of the signatory methods.
So, the section 8.
Again, number 4 methods.
So that has been rejected.
That is rejected. We have preferred the MFA.
All right.
So,
all right. So what are the facts?
Well, facts is the agreement between the parties. Initial D, page 38, contains an arbitration clause. Appellant is a government of India undertaking under the administrative control of the Ministry of Defence methods. The respondent is a transport government. Transport. There is an agreement between the parties dated 25th June 2008.
That's why you understand. So that's why we insist for a synopsis. So we would not have been put to trouble of writing everything. What is the agreement? What is this? That's why it's always better to. You are here to assist us. You should give a synopsis like whatever. The 25 agreement. Then
25th arbitration clause methods. Page 50 methods. Page 50. The by force and arbitrator is named methods. The executive director of ML to be the arbitrator. Page 50. Now, a dispute arose between the parties. So, I was responding.
Yeah, wish we had done the stenographer's course also. So fast, you are in a hurry to finish off because your junior is telling other number is reaching, so you are in a hurry. We wish that, but we don't. We have to write in longhand, so that's why we should have done the shorthand course. It would have better equipped us. I didn't realize. Become a judge, you have to do a shorthand course also. We always thought that the lawyers will assist us. Yes. So, arbitration clause.
Yes. We responded to the approach this honorable court in the CMP under section 11, seeking for appointment of a neutral arbitrator. Well, this honorable court by order dated 14th December 2012 would appoint the
What is CMP number?
CMP number is 132 of 2012 methods.
Where is that order?
Methods initial E page 63.
Yes.
2012 members.
Yes, yes.
Here, the respondent admits the arbitration clause, but I would seek a neutral arbitrator. But this honorable court would appoint the executive director Bevel as an arbitrator, page 65.
In terms of the clause.
Yes, sir, in terms of the clause. Well,
yes.
Well, suppose that the arbitral proceedings commences, pleadings are complete, the claimant's evidence is over. At the time of the respondent's evidence, again the respondent will file an application under section 16 requesting the tribunal to rule on its jurisdiction.
At the time of whose evidence?
Respondent's evidence. That after 3 years from the time the arbitral proceeding proceeds of the matter, an application is filed under section 16 calling upon the tribunal to rule on its jurisdiction matters. Based on Western Ram Reddy's case matters, no judge should be a no person should be a judge of his own cause. Based on that, they file an application. This application matters, page 69.
When was that application filed?
And that was filed on 25/7/2016. And the arbitration had commenced in 2013. Thus, on this application,
that's the problem. The administrative officers or arbitrators, they do not have idea. They are keeping the arbitration pending for 3 years. 3 years. That's how they face this. Then
when we filed objections to it, however, the tribunal would vote on the basis of the Supreme Court ruling.
Order.
Melon's order is dated 7/11/2016, edition H. Page 86, my lord. Page 89.
It has jurisdiction, right?
It says, my lord, in view of the judgment, that particular tribunal would not have jurisdiction. Not that there was no arbitration clause, not that there is no dispute, but the tribunal, because of special Ram Reddy's case, has no jurisdiction. Page 89.
But he has held, he has no jurisdiction.
Yes, my lord. Now, after this is done, my lords, instead of seeking for the appointment of another arbitrator, a civil suit is filed. Now, in that civil suit, my lords, we would file IA-4.
Civil suit, what? Civil
for recovery of money. Yes.
Number, etc.
My lords, civil suit, number,
that
OS, my lords, OS, 5714 of 2017. 5714 of 2017.
Now you have understood the importance of synopsis.
In which we filed this IA-4 pointing out section 8 of the Arbitration Act, and that it has been
IA-4 of which year?
IA-4. That's IA-4 shown as IA number 4
under section 8.
Under section 8. The finding of the civil court in dismissing the said application, my lord should get it in the impugn order edition A, order dated 22nd March 2019. The issue, my lords, is at page 22, my lords. Point number 2. Because there were 3 IAS, my lords. The common order is passed. Right. At page 28, issue number 2, my lords, which then is answered.
Which page?
At page, issue number 2 is at page 22, my lords. Answered at page 32, my lords. In paragraph number 19. This is my application, my lord, on the ground that I ought to have challenged the order of the arbitrator. I was not aggrieved by the order of the arbitrator, my lord, because it was the case of another arbitrator who ought to have been appointed. I did not choose to challenge that order. But that's a note on which, my lord, the court finds fault with me and discusses IA number 4, against which the present amendment has been filed.
Where is that order dated 22nd March 2019? Which page?
It commences at page 17.
By which the arbitrator held that it has no jurisdiction.
Yes, sir. That's going to be page 32, paragraph 19.
Sir, I'm asking about the order. I did not note the page of that order.
Okay. Initial page, my lord. Initial page is page 86.
Executive Director for Arbitration. Adjudicate plaintiff should clear copy. Say 7/11/2016.
It says initiation of appropriate legal remedy for recovery of amount.
It is not it. 22. This is
The order dated 7/11/2016.
After that, 12th March or 22nd March.
That is so far as the civil suit. They filed a civil suit. In the civil suit, we filed an application under section 8, in which the reviewed order is passed. It is once the tribunal has no jurisdiction. The respondent files a suit.
Okay, no, since you are not reading, we are reading the order, impugned order. What to do? You are only told paragraph 30. We are reading what to do. Why your IA has been rejected?
Yes, paragraph 20 levels on 19 it commences. 20 on the other hand, plaintiff states the plaintiff has filed application to the Honorable High Court of Karnataka under Arbitration and Conciliation Act, which order was passed on 15/12/2012. In CAP by referring the dispute to the executive director of the Defense Company for arbitration. Arbitrator, director of the Defense Company passed an order on 7/11/2016, holding that in view of the apex court decision, arbitrator cannot adjudicate the matter, and the plaintiff should work out its remedy by initiating an appropriate legal proceeding. Order dated 7/11/2016, passed a sole arbitrator, who was the executive director of the Defense Company, reproduced. They reproduced that order.
Fine. We have got it. Paragraph 21. All right. Yes.
Section 8 of the Arbitration Act.
Yes.
Power to refer parties to arbitration where there is an arbitration agreement.
Yes.
No dispute insofar as arbitration agreement is concerned.
Fine. It's not that difficult which you comprehend it to be. It's not that issue, right? It's non-application of mind. So he says barred by limitation when the judgment was passed on 22nd March 2019, right? No, just this order was passed on 22nd March 2019. When did you file the appeal? How? We just want to understand why he is saying that it is barred by limitation.
We filed it in May 2019.
27/5/2019.
Yes.
Appeal file. Limitation. Why is he saying it's barred by limitation? No, just wondering why is he saying that it's barred by limitation? What this is it, right?
One aspect we have point out, the statement of objection filed by them, they don't dispute about the arbitration agreement. I think that is section 8 comes into play.
Yes, right. So, Mr. He can't hear properly. You tell him that the impugned order was passed on 22nd March 2019. The appeal has been filed on 27. Madam, please assist us. You will have to. So please, Madam, please assist us. So he is saying that it is barred by limitation, right? So you will have to tell him the impugned order in the appeal is 22nd March 2019. The appeal has been filed within a period of 90 days. That is on 27/5/2019. So now we would like to hear from him how it is barred by limitation. He has not filed any objection, right? He is orally argued. Yes. Yes. How it is barred by limitation? Yes. What is the limitation?
Later it was after 2 years transferred to provincial court. That time will be.
No, we want to understand. You said it is barred by limitation. What is barred by limitation? Appeal is barred by limitation. Huh?
My civil suit, that can be taken. That will be taken from as per the law.
No. So we need to understand what the limitation. Just a minute. Limitation for filing an appeal commences from, according to you, 7/11/2016. Okay. Yes. Therefore, it is barred by limitation. But this appeal has not been filed against order dated 7/11/2016. Fine. All right. Yes. What is the date submission? Yes. We know under section 34.
Also, section 57.
What is this judgment? So what, first of all, tell us what is this ILR?
Section 33, 37 says, the second appeal is prohibited. I just go to that.
No, relax. It's our turn. Yes. Sit down. Relax. Yes. No, which second appeal?
Yes. Here orders, section 37 of arbitration on the and this shall be applied from the following orders. Section 3 order, your Lordship. No second appeal shall lie from an order passed in appeal under this section. Nothing in this section can affect or take away the right to appeal to this section. That is the thing.
How second appeal? What second?
After 3 years, they are filing. Taking advantage of not 90 days. That what the Raj Court has held. Raj Court has held you.
The order is passed in your civil suit, not in any appeal. They did not prefer you, or they did not prefer any appeal from which this appeal
It is
arises.
for both sides. Not for me, your Lordship. They are appeal.
No, we are trying to get how your submission, how this is a second appeal.
I will give them, I will give that operating plan. I did an operating plan in page 9.
Arrangement service. So I don't understand anything. What to do? No, we have understood that it is barred by limitation and there is no question of Mr. Gupta, there is no question of limitation. The second appeal does not, they have filed a second appeal does not lie. So it has to be dismissed under section 37(3). I got it. Huh?
And you are and what issue? Any side, another one issue for important point. What do you like to ask me? Not out of the gate to mention. They have a full faith legal department experience. How many junior? How many can offer an engineer?
You are an employee of ex-employee of this. Huh? You are an ex-employee of the Apple. No, we are asking you just. You are an ex-employee of this. So how do you know they have got a big legal team and all that? It's not relevant. Mister, they have not they are not saying that we have a small team of one officer. Huh? We don't know. We don't know. Where is the material they spent 5 crore? You will say anything. 5 crore which? Huh? We don't know what is the salary. That is not the issue. File an affidavit. Mr. No, we put you to strict. Orally, you cannot give a lecture. It's not a public place. We are not. You are not a leader, and we are not the audience. And this is not election. Please forget about it. You speak from the record. You are on the first. Just a minute. You are on the point that the appeal is barred by limitation. We have told you it has been filed against an order dated 19th of March 2019, and the appeal has been filed on 27/5/2019. Thereafter, you are arguing that this is the second appeal, and under section 37(3) it is barred. We got it. Now, what else? Next point. No, you are not.
I go to the High Court, 90 days is definitely for me. But what can High Court date is taken and he said,
we don't know. We are trying to understand your submission, Mr. We are not. Please understand one thing, Mr. Gupta. We told you that probably you have started your career as a young man in the law at the age of 25, 26, or you have started this career after retiring from somewhere. We want to know.
No, I started this one out of
after retirement.
No retirement. Of course, have been problem.
No, since how long you are practicing? You want 40 years. All great. Yes. So what? Yes, go ahead.
I am giving one more time for consideration of the family. But that for arbitration is now confined to only one issue. Last damage. Last damage is only the point that they speak to. They are paid number page 6. Let me be that.
We will hear you subject to imposition of cost, whatever you say. The imposition of cost with subject to heavily. So you have told us that this is the second appeal barred under section 31(3) and barred by limitation. Fine. Now what is the second issue? Paragraph 13.
My claim. The entire claim understood by way of damages that are only issue before the trial. So there are 6 units. The evidence get damages imposed by the tonight.
Oh no. Para 13.
Yeah, 14. This is like 38,221 extra transportation charges paid. This paid you. Yeah, 15. 10 lakh and cashing to bank balance. 5 lakhs. 120. That's 51,000. I have submitted before what the issue is here. Decide and adjudicate the matter whether under law of damages the appellant is entitled to justice money. If they are not entitled to justice money, I will give them. If they are entitled, I will give them. That issue is not. Instead of offering media from money, they have been tried under for arbitration, the arbitration has helped. But they are intentionally passing on payment. They are not cooperating with them. That's the what is there in the main part. What is doing here? The main class is that they are simply cooperating. Right? There is your and my order will be directed to any issue. Whether the applicant is entitled damages to others or claim from us or the liability of them, or whether we are liable. That one issue may be claimed and directly put it to a final state. Second point is your main point comes here. Who is liable for these others? Of agreement has anyone till the court has now delegate has been on issue. Who to be liable? How much to be liable? Assignment. Who to be permitted and to be arbitrated? Therefore, by clearing the issue, the office going clear and directing them to settle the matter, to adjudicate the matter within 1 month or 2 months on this issue only. We can't only about these 60 lakhs. What they are typically are submitted, they are aware of the same thing. When it came across to the final hearing, they know that order for the information. What I showed you. What the arbitration can be said. What can be said? And they are necessary. An arbitrator cannot play a role when pushing for only issue of law. It is only an issue of law. That's all my theory. But if I for be directed to print off the short, one thing, like it, and whether we are entitled for, we are entitled for damage. But that's too much. And the date of then you are has to be taken from the date, not awarded, not from my security. If the trial court has verified clearly that the sugar are gone for appeal, it's time bound. That is, time bound in order to cannot let it get done. I read you.
What are you reading? Huh?
Page opinion, your right. And my submissions are to their own record.
But para 19 of memo of appeal you are reading.
I'm reading the order. There are 19 of page 16 of opinion.
Para 19 is at page 8.
Page 32.
32 is impugned order, not memo of appeal. Yes, you see, don't say memo of appeal, it is the impugned order. You told us memo of appeal. No. What we are trying, Mr. Gupta, you told us that you are reading paragraph 19 of memo of appeal. This is not memo of appeal, this is impugned order. Para 19 of at page 32. Please read. No, read. We are not, what we are, tell us correctly. You said you are reading memo of appeal, whereas you are reading impugned order. So we are only telling that be fair. Tell that I am reading, otherwise we would not do. You said I will read para 19 of memo of appeal. It's not para 19 of memo of appeal. You are referring to the impugned order. Read para 19, whatever if you want to. Whatever. Read.
That arbitrator in law by cannot be said. It is a well-established rule of law that it is value of arbitration out. I only want a judgment on whether I am liable under law or not. Application only one on that. Yeah. It's a minus thing. It may be properly found, may be directed, therefore, and you can
No, it is very strange that in an appeal filed by the appellant, the relief should be granted to you. We have to decide whether Section 8 of the Arbitration Conciliation Act applies. No, you are submitting that issue be formed and the trial court should be directed to decide your suit. We are not concerned with that. We are concerned whether the trial court has rightly rejected the application under Section 8.
Even if in detail, there is no time our coming here, the whole issue of arbitration has to be decided. The decision put before the trial court is on law of damages. So even otherwise arbitration is not required. That's my meaning. Submission. Because of this damages clause, the arbitration only not required. Just simply prolonging procedure. This is a point of musical participation.
What is to be considered will be decided by us, right? You cannot tell us what order. Again, for the sake of brevity, we may remind you that this is an appeal arising from an order of the trial court by which application under Section 8 has been rejected. We are only required to decide in this appeal whether the application under Section 8 has been wrongly rejected or or it ought to have been, or it has rightly been rejected. That is the issue. We are not required to decide who will decide the damages. It's not issue before us. Who will decide damages? And civil court should decide. Arbitrator cannot decide. These are not the issues in the appeal. You are at liberty to argue whatever you can. We are judges. We have to hear you. Right.
I have made my submission.
Fine. Thank you.
And what should be treated from the case of Gambia. It cannot be extended by my civil suit. So my civil suit side from which there is a bar cannot be treated.
You have understood.
That will be unclear for them to ask me. And getting an extension because I won't get an extension. It cannot be allowed to take advantage of that on the issue.
They don't have any right to challenge any order passed in your civil suit. That's the submission, right? They can't challenge any order passed in your civil suit. They should be hanged to death because you have filed a civil suit.
Challenging is a fundamental right. They can do, anybody can do. My submission that it cannot extend the time.
It's not time bound. That's what we told you. The impugned order is dated 19th March 2022. Appeal has been filed on 27/5 within a period of 90 days. It is not barred by limitation. They have not filed any application for continuation.
That submission, my submission is your answer.
Yes.
The trial court passed the order, and not should be held.
Yes. We will decide this appeal. No.
The trial court order should be held.
That is understand. So we have heard this appeal. Finally, we will pass a final judgment just now, right? Finally, this appeal has been.
Trial court has held that here appeal filed before the trial court is held.
Trial court has held appeal. There is no appeal. All right, we can't make you understand. Thank you, Mr. Gupta. We have been enlightened and learned something new. That how to call an order of the trial court a second appeal. We have first appeal. We have learned now today. Thank you. Thank you for enlightening us. Fine.
However,
No, second appeal is filed under which rule?
trial court order may be held.
That's it. We will decide this appeal finally right now. The moment you leave the court, we will start dictating the judgment. Thank you. You can find out from the reader. No. We don't dictate in the lawyer's presence. This has been the practice of this court. Everybody knows. What we are trying to tell you that you should say that I didn't know that the judgment will be passed on that very day. I thought that it will be pronounced. That's what we are telling you in advance, that the judgment will be passed today itself and it will be signed before 4:45. Please find out from the court officer what has happened. Right? We are telling you that it will be decided finally and today itself, and we will sign the order before 4:45. Thank you. Thank you. What is it? You should have given earlier. Give it to him. Give it to him. Paragraph
14.
Fine. This section is clear. There is nothing to. What?
Paragraph 14. 510.
Yes.
In 2020, AR members. Paragraph 174, 170, sorry, 170. It says that usually it is obligatory to. Paragraph 170, members. The end of the decision.
Yes. No. Okay, he has argued the matter. You are not the counter. You are appearing for one of them. No, we don't want to hear you. We just said that you should tell him that what we may not get it. Yes. Enough to hear the judgment. We are not strong enough to give. Yes. Yes, please. Under section 37 within bracket 1 within bracket A, small a of the Arbitration and Conciliation Act 1996. Yes. It's been ordered dated 22nd March 2019 passed by the trial court, by which application preferred by the petition, application preferred by the applicant under section 34, preferred by the applicant under section 8 of the Arbitration and Conciliation Act has been rejected. Area on the ground that the appellant has not assailed the order dated
18.
assailed the validity of the order dated 7/11/2006 passed by the arbitrator, by which arbitrator has held that it has no jurisdiction to adjudicate the dispute between the parties. Giving rise to filing of this appeal, briefly stated that the applicant is a government of India. It is a company and is a government company. It's a government company matter. And government of India is a government company. It's a corporate body. Must be a government of India undertaking. Which one? Entered into an agreement on 25/6/2008. Appellant entered into an agreement on 25/6/2008 with the respondent who is a transporter. Full stop. The aforesaid agreement contains arbitration clause, and the aforesaid agreement contains an arbitration clause. Full stop. He said the said arbitration clause, the arbitration clause. It says in that. 500. When the dispute between the parties arose, thereupon the respondent filed CMP number 132/12 about this court under section 11 within bracket 6 of the Arbitration Conciliation Act, herein after referred to as the Act 1996, by which they said writ petition seeking appointment of an independent arbitrator. This court, a bench of this court by an order dated 14/12/2012. Referred the matter to the executive engineer of the executive director of the appellant, as sole arbitrator as per the stipulation contained in the, as provided in the arbitration clause. Full stop. At the stage of evidence, at the stage of recording of the evidence before the arbitrator, respondent filed an objection with regard to jurisdiction of the arbitrator. The opposite objection was adjudicated by the arbitrator by order dated order dated 7/11/2006, and it was held that the arbitrator has no jurisdiction to adjudicate the dispute. Correct. The respondent was the relevant order, the relevant extract, the operative portion of the order passed by the arbitrator reads as under. Page 89, para 8. In pursuance of the liberty, it is pertinent to mention here that the order dated 7/11/2016, the arbitrator in finality and has not been assailed by any of the parties to the list. In pursuance of the liberty granted by the arbitrator, the respondent initiated the proceedings before the civil court for recovery of the amount in question. In the civil suit, the respondent filed. In the civil suit, the appellant filed application under Section 8 of the Arbitration and Conciliation Act, which was rejected. The trial court intervened on the ground that it has not challenged. Intervened on the ground that the appellant has not challenged the validity of the order dated 7/11/2018. 7/11/2016 passed by the arbitrator. The said order is in challenge in this appeal. The right counsel for the appellant submitted the provision of Section 8 of the Arbitration and Conciliation Act 1996 are mandatory in nature, and the respondent by filing a petition under Section 11 within bracket 6 of the Act before this court, which was decided by an order dated 14th of December 2012 by the single judge of this court, has admitted the existence of the arbitration agreement. Therefore, it is submitted that the trial court heard in rejecting the application preferred by the appellant under Section 8 of the Act, and ought to have under Section 8 of the Act, and ought to have and not to have relegated the parties to the remedy of arbitration. On the other hand, law is counsel is founded and submitted. Finance has been placed on decision of Supreme Court so and so versus so and so 2006 SSC 503 and so AIR so and so versus so and so AIR online 2020 SC 929. On the other hand, Learned Counsel for the respondent has submitted that the order passed by the trial court does not suffer from any infirmity. Is submitted that the not cooperating with the trial court for early decision of the and the appeal should be disposed of with the direction to the trial court to adjudicate the dispute between the parties within 1 month. But as this is an issue which the civil court could solve. We have considered the submissions made on both sides and have perused the record. Before proceeding further, it is appropriate to take note of Section 8 of the Act, which reads as under. Line below. Thus, it is evident that thus from the perusal of aforesaid provision, it is axiomatic that an agreement between the parties contains an arbitration clause, the court is mandatorily required to refer the dispute arising between the contracting parties to the arbitrator, and the civil court has no jurisdiction to continue with the suit once an application has been filed. From perusal of Section 8, line below. Thus, from perusal of Section 8, it is evident that that the aforesaid provision is mandatory in nature, and where the agreement between the parties contains an arbitration clause, it is obligatory for the court to refer the parties to arbitration. So, the arbitration agreement, and the court cannot proceed with the civil suit. Civil suit. Report in Anand Gajapati Raju versus PVG Raju, bracket close 4 SCC 539, which has been followed in Hindustan Petroleum Corporation C1PN.LTD.2003, bracket close 6 SCC 503 Supra, Hindustan Petroleum Corporation Supra. As stated that the provisions of Section 8 are arbitrary in nature, and in case an arbitration clause in the agreement is accepted by both the parties, the matter is required to be referred The dispute between the parties is required to be referred for arbitration. So, similar view has been taken in so and so 2020 SCC online, right?
Yes.
The sense of an arbitration agreement is admitted by the parties, and the dispute was referred. The arbitrator holds he has no jurisdiction. He grants them the liberty to file a civil suit. It is not the liberty granted the respondent. The civil suit is filed. In that again, section 8 is filed.
Blowing hot and cold over the issue, they cannot take inconsistent stands.
Inconsistent. That in such a case, the civil court would have jurisdiction.
They have waived their right.
And in case the dispute was arbitrable, they have accepted the order. They have accepted the order passed by the arbitrator. Thereafter, they cannot say that Toro this thing. They cannot. Your waiver may also apply. Case law. This will go to Supreme Court. This is a limited company. It will litigate. They are seasoned litigates. Therefore, see that we will finalize this. But conclusion is safe. Yes, madam.
Has been taken in
So and so. Eastern case. The existence of an arbitration clause between the parties is not in dispute. However, in pursuance of the order dated 14/12/2012, passed by learned single judge in CMP number 132/2012, in a proceeding under section 11(6) of the Act, the director of the appellate was appointed as sole arbitrator. The aforesaid executive director, by an order dated 7/11/2016, has held that the dispute between the parties is not arbitrable and has granted the liberty to the respondent to initiate legal proceeding for recovery of the amount. The appellant had the opportunity to assail the order passed by its own officer, who acted as the sole arbitrator. However, the appellant did not assail the validity of the order dated 7/11/2016, passed by the sole arbitrator, and in other words, the appellant accepted the order passed by the arbitrator dated 7/11/2016, by which the dispute between the parties was not held to be arbitrable, and the respondent was granted the liberty to initiate proceeding in accordance with law. Full stop. In pursuance of the aforesaid liberty, the respondent has filed a civil suit for recovery of the amount due to it as damages. Full stop. Therefore, in the said proceeding, full stop. Thus the appellant had waived its right. Appellant had waived its right to raise the contention that the dispute is arbitrable between the parties. Full stop. In any case, in the absence of any challenge to the order dated 7/11/2016 passed by the arbitrator, the aforesaid order binds the appellant as well as the respondent. In view of order dated 7/11/2016, which is binding on the parties, it is not open. It is not open for the appellant to contend that the dispute once again should be referred to arbitration. Full stop. The trial court has therefore rightly rejected application preferred under section rightly rejected the application preferred by the appellant, has rightly rejected the trial court, in the facts and circumstances of the case has rightly rejected the application preferred by the appellant under section 8 of the Act. The order for the reasons assigned by us in the order for the aforementioned reasons, right? Assigned by us, supra, we are not inclined to interfere with the order, impugned order dated 22/3/2019 passed by the trial court insofar as it rejects the application under section 8 of the Act. In the result, we do not find any merit in this appeal. That thing, you leave some blank, dash, we will add some. So in the opening paragraph also you write, this appeal has been filed. This appeal emanates from judgment.
Arbitration Conciliation Act has been filed
Emanates from an order dated 22nd March 2019 passed by the trial court insofar as it rejects. Insofar as it rejects the application. Insofar as it pertains. So far as it pertains to rejection of an application filed by the appellant under section 8 of the arbitration conciliation. Here is in order to appreciate whatever grievance of the in that paragraph only, grievance, few facts need mention, then facts. We'll hear it, madam. It is admitted for hearing. Change the order sheet, right? Order sheet separately, you record with consent of the parties, the matter in that 35. With consent of the parties, the matters are finding in view of this thing, judgment or reasons assigned. So you say in the operative portion, they will list again for this IAS. Pending interlocutory does not provide for consent. Yes. But at the time, you want to withdraw?
I appear for appellant in this matter. My lord, serial number 37. My lord.
Appeal is admitted for hearing. Issue notice record.
Much obliged.
38, government advocate. Mark has present, learned advocate. K1 of 21 is dismissed as not present. Learned comment advocate submits that the learned single judge has followed the single judge dated 24/7/2020, passed in WP number 101965-101969, part 2015. Full stop. It is also submitted. It is pointed out that against the opposite order, writ appeals have been preferred, namely WA number 1,86 of 21, 1,03 of 21. In view of aforesaid submission, list for analogous hearing along with so and so and so and so.
The RS Ravi Associates, government advocate.
The respondent has already taken assessment and has also taken and second respondent, instead of
Whatever it is, we are not concerned with all that. This issue is whether why extraordinary jurisdiction under Article 226 should be exercised in the wake of an alternative remedy. You have a remedy of appeal under Section 49. So you
again going back to
on that ground, it will be set aside. Right? You will tell the tribunal that, see, your order has not been complied with, your subordinate officer is acting like this. So it will not take any time. But, yes, party presence. This intra-court appeal arises from an order dated 9th of November 2020, passed by learned single judge, by which a writ petition preferred by the appellant has been dismissed on the ground of availability of an alternative remedy. Paragraph. You heard learned counsel for the parties at length. The appellant had assailed the validity of an order passed by Deputy Commissioner under the provisions of Karnataka Land Revenue Act. An order of the Deputy Commissioner dated 27/2/2008 passed under the Karnataka Land Revenue Code. Full stop. It is not in dispute that against aforesaid order an appeal lies Section 49 of the Karnataka Land Revenue Act 1964. The learned single judge, therefore, in the case has rightly to exercise the extraordinary discretionary jurisdiction under Article 226. Yes, relegated the appellant to the alternative remedy. Paragraph. However, in the facts of the case, it is directed that in case the appeal is filed within a period of 30 days from today, the appellant shall be entitled to, it is contained in Section 14 of the Limitation Act 1963. The aforesaid modification, the appeal is disposed of. You file an appeal.
But I appear for the appellant. But I pay for just 2 days accommodation because my grandchild is not well.
Hey, Mr. Nayak, what has happened? Of
Only
late,
2
you
days
are not
accommodation.
arguing any case.
Yes,
Of late, you are not arguing any case before us.
So I will
You
argue
always
the
seek
matter.
adjournment.
My lord, can it be taken up in the afternoon and I'll argue the matter? I'll
No,
come
no.
in the afternoon and argue the matter.
No, no,
May
no.
kindly be passed over. I'll argue the matter.
I'm ready, my lord. But I could not get the file. I gone is the matter in the after.
Yes, he said.
I could not get the file, otherwise I would have, because I know the facts of the case. In fact, I have only prepared the writ appeal.
Might be a service counsel for the appellant.
Monday, my lord, or do it tomorrow.
IA 1 of 2021 is dismissed as not pressed. Current counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same list after 2 weeks.
41, the arrangement government limited.
Your petition has been dismissed as premature.
That's why you must now order the Deputy Commissioner of Russia. There are some complaint against the
It's an official.
yes, official correspondence. Now, why not this official correspondence?
Where is that? Which page is the correspondence? Page.
Page 87. You are watching by this order. Now, this is order to get that 192A.
What happened? Action has been taken against you. No. This was past 6 years ago. Action has been taken.
Now they are fixing 192A. Before passing 192A,
No, so supposing if a person commits a theft, the police before lodging is this thing, like he will say, I have an opportunity to be heard before first FIR is lodged against me. We cannot stretch to such an extent, right? So whatever proceeding you the learned single judge again said, please understand it is for the authorities to implement. If implementation is made open to the petitioner to challenge consequential order, whatever we will say that you don't have, if this is this that you have a right to be heard, we will say you don't have any right before an action is initiated against you.
The order of the report of the Assistant Commissioner of Lodging, the DC passes the order requiring the person to take action to PA and restore the land to the forest department. Restoring the land to the forest department.
It has not been implemented for you. As and when it is implemented, they will have to, supposing if it says that the land has to be recorded as forest land, then they will give you an opportunity. 6 years have passed, they have not done anything. You should be happy rather instead of precipitating, getting us. No, Mr. That means the interdepartmental correspondence also doesn't take place, right? It can't take place according to you. Supposing if a deputy commissioner during the inspection somewhere learns that there is an enforcement on forest department, he comes back. Just a minute. We are trying to understand, not that he will be heard. So he comes back to his office and writes to the commissioner that I have noticed this thing, you take action for redemption of that forest land and remove the enforcement. So those persons will come to the High Court, say, no, quash it, and put the deputy commissioner behind the bar because he cannot write this until unless we have been heard. Land is granted to us. So whether it's an internal correspondence, not addressed to you. That's why learned single judge has said, if implementation is made, it is always open to the petitioner. Officers and hearing officers and employees. But what is the subject? Please come to page 87. Read it. Page 87. Subject. No. English translated copy you have filed. Officers and employees. Officers and employees. You are an officer of forest department. You are an employee of forest department whom you are trying to protect by means of. Then it doesn't say. What is your argument, Mr. Bhandari? We really don't appreciate. If something wrong comes to the notice of Deputy Commissioner, he cannot initiate even an action. He cannot even write to his subordinate officer that this is what has happened, you take action. He can't even do that. It should be quashed. What is the subject? Please read it. Read it aloud. We should know what is it. No. Initiation of criminal proceeding. Read it. So on this basis, no action has been taken against you. He is saying that take action against the officers who have colluded obviously with you to make a false record. So you are there to protect yourself as well as them, saying that no, corrupt officers should be this thing. No action should be taken against them. No, Mr. This is what we feel is that it is absolutely an innocuous order passed by the learned single judge. That gives an impression that you are trying to protect the corrupt. No. You are. That gives an impression, and we will not refrain it from not writing in the judgment that you are trying to protect the officers, corrupt officers, and the forest department, and they have acted prima facie. It leads to an inference that they have acted in your collusion. You and officers have acted in collusion, and this petition is trying to protect them. What has been done? What has been done? What has learned single just said? That if any implementation is made, you have the right to. This is premature. However, you see, Mr. This order does not mention your name, take action against you. It is corrupt officers and employees. Like take action against the erring officers and employees. You are not an officer, not an employee of forest department. What is this? Initiation of what is the subject? Again read, Mr. Bhandari. You have read it once, again read it. Again read it. We don't know. No, if the land has been allotted to you in accordance with law, you should not feel afraid. They cannot take any this thing like this. No. These three departments, police, revenue, and education. These three departments are this type of. So what is this? This is not. What is this? What is this? Do you think we are running from? What is this argument? Three departments. Go and meet the CM. What is this? What you have to argue? It's premature, rightly been held to be so. And you have admitted you have managed Deputy Commissioner also. That's why no action has been taken for 6 years. You will dismiss it by saying that, Madam, you take this Deputy Commissioner, we will direct the Deputy Assistant Commissioner to take action. All protecting the garb of these appeals and petitions. All corrupt officers are being protected. It's not fair. Yes. What else? No, nothing. There is no presumption and there is no reason for us to presume that they will act in contravention of law at this point of time. But it is only an apprehension. Why we should presume that they will act contrary to law? If they act, the single judge has granted you liberty. Frivolous. He has granted liberty. Paragraph 9C. It is always open to challenge the consequential order. You have been granted the liberty. First, you don't have any locus to challenge this communication because no action is initiated. If on the basis of that order, any consequential order is passed against you, you challenge it. That's what has been said. Nothing. An order of dismissal on merits, or you would like to withdraw? Mr. Harish Bandari, learned counsel for the appellant, after arguing the matter to some extent, seeks leave of this court and withdraw the appeal. The appeal is dismissed as well. Again, 1 or 22 does not survive. Why next week? You are not in a hurry, right? Why you? Why? That means you had not prepared the case. Mr. Please, listing of a case requires a human effort. We go through the file and then you just stand up and why? So why are you here then? Why have you not brought file? Are we responsible? Then what is this argument? It requires a human effort. We should think. Right? Case is listed. You know that case is listed, and you tell us that you are not. That means deliberately you did not bring. So how do you know that this case is listed? We could understand that if you would not have appeared at all, many a time you miss the case. So therefore you don't bring the file, you don't read it, you don't not aware. But what is this appearing at the time when the case is called and telling that I have left, I did not bring the file? Why? We understand that if you are not ready. If this file is there, if you don't have this file. The HR Sunil Kumar, learned counsel of the appellant, appears. Raghavan, learned counsel, appears when the case is called. However, he states that he has not filed. He has not brought the file. Therefore, prays for adjournment. By way of intelligence, hearing is of the appeal is deferred by 3 weeks. Next time, this will not work. We will send this to a book is being written, law of adjournments. So this we will incorporate. This was not suggested. It's a new ground that appearing and saying that I did not bring the file. This can also be ground for adjournment. We didn't know this. Good. very innovative, fertile brain you have. Thank you. Yes.
What is this? Sri Ramesh Kya, Sri Sharat Kumar Ji.
What has been done, Mr. Natras? Tell us. Dismissed. Appeal is admitted for hearing record. Learned counsel for the parties jointly submit that the matter is likely to be amicably settled between the parties. They therefore undertake to appear before the Bangalore Mediation Center on why 27 June. 27 June at 3 p.m. Yes, madam. I can make list on 16th of June 2020.
The 45, Srimati Rakshit Karije, government related.
No, there are 7 cases. What is it? Matter has been remitted to the managing director, right? You are also a big litigant, right? You will now go to Supreme Court also. No, we don't know. We don't know instead of whatever. Managing director, by now, managing director should have passed an order instead of litigating. So you are ready? So you people are ready? Copy. Wait. Says we don't. Acknowledgement you have. Which case you are appearing? To which case? Your number? 45.3. So you are appearing in 45.3, right? So he says that copy has been, she says copy has been supplied. You got it, but it's a common judgment, right? The point is common. So merely because he is filed 3 caveats, he is not entitled to 3 copies. Supposing if you filed 100 caveats, so shall we say 100 copies should be, the point of law remains the same, right? That's what we are trying to tell him. So either you are ready or not ready, whatever it is. Then there's no point in hearing the case in piecemeal. Mr. will decide it right now after hearing Mr. Prasanna. No, what is it? No, according, forget about the petition. Why have you succeeded before the single judge? Tell us. Forget about the copy and petition. You have the order, you have submitted single judge according to you. Madam, where is the acknowledgement? No, acknowledgement is there. Acknowledgement is fine. Which the matter? Yes. We are trying to understand from you why it is insisting for more copies. Your appeal is identical, right? Which? Sir, common judgment, is it not? Why you told this single judge that it can be decided by a common judge? He has decided it. You are not filed any appeal against that, saying that it should be decided separately. So then you have accepted the judgment passed by the learned single judge. What is it? I mean, we can understand if you are not ready. We can understand that. But saying that copy they have served, they are saying that acknowledgement is there. Now, do you want this court to hold an inquiry? Case acknowledgement is there, madam. Where is it? Yeah. 45.3 is to see the acknowledgement. Give him. Huh? Same thing, Mr. He just now told all appeals are identical. What about this thing, Mr. 45.6, madam? Have you submitted? No caveat, sir. Give it to him, not to us. How? Which provision? It's one caveat for 100 cases. Tell us. We want to learn. Though I will not be filing any caveat in my life right now, but still I would be benefited, no? That how under which provision, like 1,000 petitions, you can file one caveat. 1,000 cases, one caveat. Where is which provision? So then consequently, if you can file, then you are entitled to copy. Otherwise, you have the option to tell us caveat should be confined to which case? Which case? 45.3. You have received the copy. Huh? It is 45.3 only. Nothing can be done. To be ready, no? He is still stuck up with you. We will have to pass an order. Huh? No, nothing. So we will take it a day after tomorrow. Otherwise, this is a big issue, right? That he has not received the memo of appeal. We have to adjudicate this. He has the right to challenge this order in the Supreme Court. Right? Yes. Mark the presence. The counsel for. What's your name? Learned counsel 45.3. WA 50/2022. Learned counsel for the appellant submits. Respondent submits that though he has filed one caveat in three in respect of orders passed in 3 late petitions. However, the aforesaid caveat petition be confined to the order passed in order dated 23rd October 2021, passed in WP number 5796/2021. It is further submitted by learned counsel for respondent that he has been served with a copy of memo of appeal in the said case. However, he prays for adjournment. This on day after tomorrow. Day after tomorrow is what? Tell him, Mr. You explain to your friend that issue is common. This is not, doesn't matter. Right? Here's what the issue is only it should be remitted or it should have been remitted or not, whether he has the power. Whatever it is, we don't know. Whatever. That's the only issue. Whether it be one case or 70 cases, doesn't matter. Explain to your friend. Explain to him and ask him to be ready. Explain. You give a synopsis, Mr. Prasanna. Madam, you prepare synopsis short date wise. Notice record. Record. What is it? Repeated for hearing. Is not listed. No application was listed. 47. 48. Has happened. Application for stay that we, without seeing you, we can make out that you are for applicant and you have filed the application for stay. What has been done? You're doing their job. He is finding out for you what has happened.
Section 5 under section 13. Against wife is hereby allowed in part.
What has been done? What is the decree against which you have filed the appeal? What part of it you got?
Filed by husband. Permanent element. 13, 1A and 2. Is allowed in part.
It allowed in part.
Marriage was dissolved by a decree of divorce. And petitioner is entitled for permanent alimony.
Permanent alimony, how much?
8 lakhs.
Why it should be allowed in the first place? Entertained appeal. Why? 8 lakhs is a reasonable permanent alimony. You are happy with the divorce, right? And you don't want to pay. Right? You are unable to see the consequence. What can be done? Oh, you did not seek any employment, this thing, maintenance from her. You should have sought maintenance, right? From your wife, that she is teacher and you are not doing anything. You are unemployed, right? You do begging, begging in the streets, beggar. You are a beggar. What do you do? Huh? Okay, then what is that? Practicing in Mysore, he has to pay 8 lakhs. Nothing. On this very ground itself, it should be dismissed that he is an advocate. So nothing, no stay. It's on merit as well as IA 1 of 2020. Let's see if we can bring about any compromise. Yeah, we should notice this. If you want us to dismiss the application, we can do that also. No case is made out. You are a practicing advocate. Don't deposit. You are an advocate, you know how to play with this system. Right? Nothing happens. Your wife is lucky that she has got a degree for divorce. You are happy with the degree of divorce, you don't want to pay permanent alimony. How is it? 8 lakhs. It's not that 1 crore is being demanded from. Only 8 lakhs is a reasonable sum permanent alimony. More than Mr. Counsel, whether or not she is entitled, the court decides. You cannot decide. If you can decide, you write it that she is not entitled and do whatever you can. What is this? What should we do?
So your appeal is admitted, notice is issued.
If we don't want to grant. No, this not. Nothing, you don't have anything, right? So there is nothing. A person who has nothing, he doesn't fear anything. Only the person who has something in life fears that he may lose it. You are not in a position to pay. Be happy. Nobody can do anything against you because you don't have anything. Here we should notice. You want us to, we don't want to pass it projecting. We want
ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಂತ ಕೇಳ್ತಿದ್ದಾರೆ ಸಾಹೇಬ್ರು. ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ, ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
We will reject your application.
Why don't you understand?
Go to Supreme Court then, whatever. According to us, no case for stay is made out. Ex party. You want us to pass an order, we have only entertained it. So it's very difficult. Now onwards, we should probably keep an advocate here to assist us. Good idea. Tomorrow onwards, we will ask some advocate to be here and
Standing
give him all matrimonial disputes. He will tell them because we are not supposed to explain it to him if he doesn't understand. Pass an order, then explain to them all. See, Mr. Nataraj, in matrimonial cases tomorrow onwards, request some lawyer to be here in the court and give him all the files so that he will interact with these people and make them understand. We are not sitting here to explain it to them. You want us to pass an order on application for stay, we will pass an order. Right? So he is not in a position to pay. All right. Okay, hard on the question of admission. So IL number 1 of 2022, an application seeking stay. Learned counsel for the appellant submits that the appellant has assailed the validity of the impugned judgment insofar as it rejects the application, insofar as it grants the application seeking permanent. Very difficult question. We are issuing notice. You don't want to. So parallel communication is always very easy, right? Why this? You feel that we are your enemies. So whatever we tell, you say no. They tell you more. The moment they tell you, you understand. Because they are your friends and we are your enemies, right? We are sitting here to harm you. This is the understanding. Unfortunate. We don't know respondent or the applicant. We have nothing to do with the case. We have issued notice only so that we can bring an amicable solution to the dispute. It's not a case where stay should be granted. Delete everything. 49. CN Kumar. It is admitted for hearing. Hard on the question of admission under the IA 1 of 22, appeal is admitted for hearing. Issue notice after record after hearing learned counsel for the applicant. It is direct. No, what parties are you are seeking an injunction. Yes, that's all right. You then say same order issue notice. Admission as well as IA 1 of 20.
Appealing for the appellant, Your Lordship.
Appeal under section, wife's petition under section 9 dismissed.
9 dismissed.
Husband's appeal is
record. To request some counsel in matrimonial matter. Panel to be here and give him files. We can't explain to these people. Like this. 51.
Serial number 51, my lords.
Admitted for hearing issue notice record. Now your case has been dismissed. Yes.
My lords.
No.
My lords, serial number 51, my lords.
Why are you not here in the court? That's why we have dismissed.
My lords, I apologize.
No. You are a young man. There is no reason for you to be in the office or at your residence. You should have been in the court. That's why we have dismissed your appeal.
I apologize, my lords. I apologize, my
No
lords.
apology. Nothing. Not accepted. Dismissed. Fine. Next case. What is it? All right. What is the stay you are seeking? What is the stay you are seeking for? 5 means see, letter appear record. Notice we are issuing. 53. We discussed. Yes.
Serial number 53, my lord.
Dismissed. You are not here.
My lord.
You are here, man, right? Why are you not here in the court?
Sorry, my lord. I appear for appellant, my lord, in this case. 53 and 54, my lord. My lord, in this case, my lord, appellants are for stay.
What stay? Your petition has been dismissed, right? What's the execution?
My lord.
After dismissal of the petition also, there is execution. You filed a petition under section 13 that has been dismissed, right?
Yes, ma'am.
You are right. Then what execution? What stay is he seeking?
My lord, the Honorable Family Court, my lord, granted my lord, restitution of conjugal rights, my lord, against the husband, my lord.
Admit, then issue notice on IA, right? Both merit and IA. Yes. Same order. 54 also. Admit notice.
It will be a good ground. I was later.
Don't seek stay.
In restitution cases.
But who will explain to these people?
55.
What is it? You are thinking right. Admit issue notice also record also issue notice on 2022 after hearing learning counsel for the appellant is admitted and operation you will be to and agree so far it dissolves the marriage between the parties shall be registered during the pendency of the yes.
First our matter, number 34.
What is this? This is the only password. Any of it? Only password. Last. No. Have you filed? No. Have you filed an application? We will not look into documents like this. You have to file an application for taking additional documents on record to put them to notice. With synopsis, you cannot next. Huh? We don't know. Have you supplied him? Right? Are these documents part of the record? If it is so, then there is no problem. Is it so? joint memos and matters arising out of the family. Right. So it's already on record, right? No new documents. What is the age of the son? Half years. And what about daughter? 9. 16 divorced. Okay.
What order ಮಾಡಿದಾಗ ಕಳಿಸಿ ಅಂದರೆ ಫೋನ್ ಮಾಡ್ತಾರೆ.
Yes, sir. Yes.
On account of dispute between the wife had gone to the parental moving day. Thereafter, she returned and she filed proceedings before the trial court. She sought an interim order protecting her custody of the children. At the first stage, for the trial court, the husband entered appearance and undertaking was given that the children shall remain in her care and custody. Thereafter, I was referred to mediation. During mediation, there was an instance in the mother's family agreeing at which point in time for a temporary period of 20 days, the custody of the children was handed over to the father. Express undertaking the children would be returned. That undertaking was not complied with, it was reneged. So for a period of time, when the proceedings were pending before the Lord, the children were with the father. That arrangement, my lord, was
Which period? You have to tell us the period.
between September October 2016.
September 20th June 2016 till
21st October 2017.
21st October. So they were both of son was with the respondent. So you told us 20th June 16 to 21st October 17. Just a minute. Then just a minute. 20th June 2016, children voluntarily handed over. Over respondent. Then
Over the son, when the both children went to the mother for visitation, the son was not fit.
when was the daughter sent back?
On 2nd of May 2018.
So son is with the mother.
Yes.
May 18.
The mother was on 21st of October 2017 and the daughter was 2nd of May 2018. I had visitation with her.
No, no. You told us just now that 2nd May the daughter was sent back to you. It's fine. Thereafter, you told us that both children again they were sent for visitation to the wife, right? Then thereafter, the daughter was sent back on 2/5/2018 to you. On 2/5/2018.
I had to return to the order.
Well, which order?
So that was WP.
No.
Which is from 20th of June 2016 until 2/5/2018.
Fine.
2018.
Now, what is the position? Since 18, they are with mother. So this order has been stayed. Order granting custody to you has been stayed. Interim order, right? So the guardian wants proceeding. You have been granted the custody of both the children, right? But the fact remains since 2018, 2nd May, the children are with mother. So what is, yes, what do you do? Plan. Ah.
On the foreground. One is she is in an adult relationship with her own mother-in-law, her sister's husband. Entire family has abandoned her. The parents, her sister, no one has come before to propose a case. The second is she has attempted suicide 4 times in the past, medical record produced for the family. Undisputed points in time, her father and brother have given indication to the police that if anything happens to her daughter or her attempts of committing suicide, her son-in-law should be allowed to be an absolutely. The education of the qualification should be well standard.
Well standard. That's why all the trouble. With no education, that is the problem.
She has filed complaints against the husband and his entire family for 4 criminal complaints. All criminal complaints were about the police. From 2018.
No visitation rights also.
I had visitation rights by virtue of order of resolve report. A joint paper was filed for resolve by both the parties.
All right, fine. Let it begin. Yes, yes, please continue in your own way, whatever. This is final hearing.
I separated from my husband. I had the custody of 4 children.
When you separated?
I separated in 2016.
Your 12th standard. Right?
I
No, you don't do anything. Okay. What separated from husband when?
September 2016. 2016. And then after 5 years, petition.
So separated from husband on 25th May 2016.
For the prayer saying that he will be granted custody and guardianship of my minor. After the incident on 20th of June 2016, the date of the respondent, that the family in order to take this recognize this that I should not take the children.
When did you? Went to Delhi on 20th June. Why? 20th June 16. Mr. Who went Delhi and Bangalore? It's all irrelevant. What is the criteria? What is the crux of the matter? What is it? What is? So you have told us your 12th standard homemaker. What? What are you doing? And why welfare lies? Welfare of the children lies. You can't guide them. You are 12th class. You live alone.
Current moment, I have a separate residence.
But you live alone, right? Live alone with the children.
Yes. Except I
Live alone with children. Parents in Delhi.
Parents. But I have been the provider of their infant nurture. I have been the care of their mental, emotional health. All times the custody of the children has been with me. I is period between
20th June till
in this period. At all times, Prior that to and thereafter.
Report of was ordered to be placed as per this order.
What is your source of income?
Income and all. I am effectively relying on the support provided by my parents in order to discharge all expenses related to children. Last 1 year, all expenses have indeed been discharged by me.
Dated 18 August 2021.
Where do you stay? In Bangalore itself? Bangalore. No, but you are also in Bangalore, right? Yes. What happened to the divorce? It's pending.
The petition filed by the husband on the grounds of stability and adultery has been allowed.
Oh, what is the decree? Decree, judgment decree. Tell us. Based on record. Yes, yes. What is the date of judgment and decree?
Dated 27 January 2020.
22. Adultery and cruelty. So you have filed an appeal which is pending. It had to be filed. Barred by limitation. Okay. Oh. But that entry has been proved, right? No appeal file. But you should, I will forget about the case. What should be the impact of a young growing girl on your relationship with your brother-in-law? What's your response to this? This is a factor which we are taking into account. You are in illicit relationship with one of your relatives. A young child, girl child, what impact it will have on her mind? You are living alone, right? Yes, no. The fact remains that as of now, you are living alone with children. You are 12th standard only, no source of income. We are just trying to stay. So tell us, in other words, why the children should be, how their interest would be or welfare is secured if they stay with you. Why?
Allegations against me as a spouse,
Why?
It may be true that a person may be a poor spouse, but not
Maybe
so
a
disqualified as being a poor parent.
mother, maybe a good mother.
And the other way around, person may be a poor parent, but may be a good spouse. And there must be an allowance of the same also. If they're acting detrimentally to the interests of the children, they endanger their welfare.
No mother acts detrimental to the interest of her children. That's a universal rule, and we are prepared to accept it, Mr. Universal, no mother would ever act contrary to the or detrimental to the interest of her children. But the question is, we have to decide the welfare of the children. They are growing. Your son needs guidance and love and affection of the father as well. You cannot. How do you overcome this handicap of your limited educational qualification?
I am not as educated as I'm not as money as my husband. But if that were to be universal observation.
No, not universal. Not universal. Facts of the case. We are deciding in the facts of this case. You tell us, if you make out that the interest of the children would be well served if they stay with you, we will grant you the custody. But you have to make out a case. We are putting you a direct question to you. Why? Tell us 1, 2, 3, 4 reasons why they should stay with you.
The custody of the children was granted to me within an order by the Honorable Court in the Rectification. That order has not been set aside or challenged. The rectification that granted me within custody
We don't know what is the writ petition. You have not told us how that writ petition arises, whether that order, this is a final order passed in guardian and what's act proceeding, right? This final order binds the parties. You can't rely on what is it? That was against an interim order, writ petition. That's fine. That's over now. Post the judgment passed by the court, why you tell us? Say 10 reasons why the children should, why custody should remain with you. Why? Tell us. Because number one, you are a mother.
What? I am a mother. Number two, the daughter is a daughter and she's of tender age. And I might be better suited to raise her. Even the years
Daughter is of tender age. Fine.
So as the older child is concerned, he is now 15 or 16 years old. He is capable of making an intelligent preference.
So 14. Obviously, he will make a preference in your favor. He must have developed so much of hatred for his father that he would not even like to see his face.
Not at all, my lord. If anything, the trial court record will indicate that the boy is actually very neutral, very tender hearted. Obviously, his heart that the two parents should cohabit with one another.
Yes, this is what normally happens. This has been our experience. All right. You know what is it? Yes. All right. So number one, daughter is of tender age. Then what? Son.
Son is old enough to make intelligent preference.
So old enough means what? I mean, he wants to continue with you. What? How do we know that?
The underlying reasons for that are mentioned in the trial court record we find yes. But in October 2017, one of the dates that
All right, we'll continue after the case.
Yes.
Retain a joint family. So your parents and
my mother, and my
brother, wife and children. How many children?
they always lived together.
Yeah.
From the date of my marriage until separation, the entire family was always together.
What the age of the children?
What my brother's son is about 17 years old, same around the same age as my son. His second child is about 7 years old.
We continue. What else? Yes, anything else? Of course, yes. Anything else? What else? You have told us that
facts that took place while the matter was pending before the trial court. And there are allegations of physical abuse of the older child at the hand of the mother and the father. In October 2017. In the father's case,
when
given 21st of October 2017. So abuse at the hands of the father.
what physical issue? What happened? What did father do?
The facts are put forth, and this is from the complaint that was written by the child, was that while the children were in the parent custody,
Like, by whom? By your son? To whom?
the Secretary of Police, HSR layout police station. Legal case.
Complaint filed by his son. Which what?
Complaint filed by the son. Alleging
To whom it was filed?
it was before the sub inspector of police, HSR layout police station. Marked with exhibit B24.
What does it say?
Medical legal case which was registered after the examination of the child at the Greenview Medical Center. In Bangalore. What happened, as per the boys say, is that when he was in the care and custody of the father at this time, there were a lot of queries being directed at the mother, which he was unable to bear. And he decided to interject this conversation which was happening between his father and his paternal grandmother. And when he interjected, was when he was beaten up by the father's brother, and also the father's mother. Beaten up really brutally. His account of it was that after he was thrashed, he was, his mouth was like closed, the TV volume was raised up, curtains were closed so that, nobody could hear. He was locked in that room. We found out about it the next day. There was a order of the family court that had granted some visitation to the mother during this time. When we got to meet the child the next day, we noticed that there were visible injuries to his cheeks, to his lips, to his nose. These injuries are also photographs of these injuries have been the trial of my lord. Medical case.
What happened to this coach? He was convicted.
The report came to be filed by the police for that matter, against which we filed a protest. And the protest, because of the absence of representative mother in these proceedings, we had to his father during the time. That matter was disposed of absent. understanding the same.
Who accepted? Court accepted. So magistrate, so did you challenge this order further?
The client's capacity to challenge and escalate orders is limited by her financial capacity.
All right.
In 5 years, 6 years of litigation, we are able to clear in matters that we are able to, and beyond that, it becomes a little bit difficult. I can even advise and instruct for going through something that is dedicated only towards the upbringing of the children, rental of the house, school fees, education expenses, medical expenses, quite substantial. Is that along the way going to be available in law? You will not always have the resources to be able to contain. But insofar as the effort of concern, I would like to mention that this happened when the court below was seized with the parents' patriot jurisdiction and was essentially the guardian of the welfare of the child. So this allegation of this incident of abuse happened while a court is exercising such parents' patriot jurisdiction. Now, that was in place at the time. So, my lord, the children at this point in time were with the father. As I mentioned earlier, I had voluntarily given the children to him, saying I have to visit my family in order to participate in a remembrance and grievance. But when I come back, there was a written undertaking the children would be returned to me.
This must have been dealt with, right, by the court.
Yes, the
This
court-
you must have raised the issue before the family court. Court must have dealt with it.
At that time, the court was very responsible. When this happened was when I brought to the Honorable Court's attention that this had happened. The Honorable Court had passed an order that said visitation to the mother and visitation to the child is returned back to the father. Which, of course, on that day, after the physical injuries were detected on the child also refused to go back to the father. The matter ended up in the trial court. The trial court directed that the children be brought home. So the trial court had an opportunity to meet with the child to see what conditions he was in.
That's all right. So,
At that point in time, the child's disinterest or disinclination to go back to the father was recorded by the officer trial commission, and a day-to-day inquiry came to be conducted as to where the children's custody should lie. The matter was heard every day for 10 days, and then thereafter the trial court decided that the children should be with the mother in this circumstance. At that point in time, I have absolutely no grievance. The trial court did a splendid job in order to come to the rescue of this child. So in the final adjudication of the matter, my lord, this issue of abuse and assault is not something that the court has really looked at. The court has looked at essentially a qualitative
so it's
analysis.
only one incident which has not been proved. It's only one incident which has not been proved legally. Please understand. Well, allegation anybody can make. I thought, as a court of law, we were to what is the material to prove it? I mean, allegation is fine that it is trashed, TV volume raised. Nobody, I mean, ordinary course of events, Mr. Grandmother participating in beating the grandchild, at least they are not inclined to believe this story. I mean, father may, if he is cruel, he may do so. Grandmother, we cannot accept. It's unnatural conduct. All everybody you are roping in. You did not rope this thing, brother's wife also. Good. Otherwise, you should have said that brother's wife also assaulted him. 4 of them, and he was made. They have to be really inhuman to deal with a boy of tender age. So they are. If it is so, then according to me, they are not fit to live in a society, civilized society. If they behave like this with the child. All right. That apart. Fine. So fine. All right. So next.
Now, this was the issue that, in my opinion, really caused the rift in the child's mind insofar as the father is concerned. Of course, there is a contest between husband and wife, but the loyalty of the children is towards the family. They cannot be called upon to choose mother or father. At all points in time, in my opinion.
So we are deciding. We are not calling them.
At that point in time, after this incident,
They are deciding this, and we will assign reasons. Whatever we decide. Fine. Let's. So yes. So eventually, what else? Yes.
So this was the incident primarily, my lord, that set it off.
That's fine.
Thereafter,
Next. We are just trying to tell you that incident has not been proved in accordance with law. It remains in the realm of an allegation. Fine. All right.
I tried
Next.
to prove these allegations by examining certain witnesses, of course, being the child himself, being the complainant in the matter.
And there is a report also. Report also, right? The medical report. Where is this thing addressed? What next? Yes.
After this incident, the matter was heard by the court below for about a year, 2 years or so. Then the matter was heard before this honorable court. During this time, there has always been an endeavor, at least on my part, of course, done counsel for the other some sort of a parenting plan, some sort of an arrangement to be arrived at. Any application or any request for facilitation that may have been made, I have never resisted it. Rather, I have tried to facilitate it. The interaction between the father and the older of the two children has always led to some sort of a turmoil in the child because of certain things that the father probably holds against the child or against the mother. A little bit of restraint in language would have been advisable at that time, when that restraint is not been there, the child has suffered. In addition to this assault, in addition to being subjected to this litigation, the father, being the earning member of the house, had at least initially he was paying the school fees on time, which I am very grateful. However, after this appeal was filed and the order of the lower court was said, the father started becoming very irregular, deliberately, in my opinion, in the payment of school fees at a time when education was full fee virtual channel. As a result of which, the children got locked out of their virtual classes and had to miss some of their tests. And the facts of what was going on started becoming known because his own cousins, who are the father's brother's children, are also studying in the same school. Now, their classes are uninterrupted. Their fees are being paid on time. My client's children's fees are not being paid on time. They are not being allowed to attend these classes. So that kind of an embarrassment he suffered among his peers. And of course, as the learned counsel for the respondent is also aware, he suffered a little bit of, one can say, teenage disappointments that come with unrequited affection for somebody in school, which obviously also, given the fact that the child was of a young age, had been through a little bit of emotional turmoil, caused him to suffer from depression. Now, this depression during the pregnancy of this appeal got really heightened to the point that the boy was not sleeping at night. He was trying to harm himself. And it eventually fed to us to inform the honorable court that these things are happening between dates of hearing. Our date for me to come to court on a day and say the child has done something really untoward that I did not reveal to the court. But I had to reveal to the court that the boy's mental and emotional state was so turbulent that he was at a risk to himself. Which after I made the submission, of course, the father was concerned. He wanted to meet the child. I did not say no. But in his meeting with the child, once again, it is only allegations, your mother did this, your mother did that, rather than trying to find out whether some workable solution can be done.
So how do you know what he met in your presence?
Oh my God, at the end of the day, any submission I have to make to the honorable court has to come from the client. It has to be told to the mother. Of course, I personally have had calls at 1 o'clock, 12 o'clock in the night when that boy is trying to hurt himself. The mother does not have somebody else to try and calm him down. I tried my best to calm him down. I visited the child also when he was sitting at home as an inpatient for about 3 weeks or so. So I do have to say that I have some sort of a relationship with him where he can at least tell me what is on his mind. At the end of the day, though I am the mouthpiece for the mother, I believe my duty in this case is towards the welfare of the children. Whether it be with the father or whether it be with the mother, as long as the children are happy, I think I would have discharged my duty well. So I endeavor to maintain that sort of relationship. Now, for that reason, my lord, he was hospitalized at Minhan's initially. And at Minhan's department of psychiatry, he was unable to form any rapport with the consulting doctors over there. And thereafter, he was admitted to the St. John's Hospital. And at St. John's Hospital, he was there along with his sister and his mother as an inpatient. At that point in time, my lord, counseling sessions were undertaken by the specialists in this domain, both at Minhan's.
But all this happened when the son was in your custody, right? Somehow, or the other depression, he suffered from depression when he was in your custody.
Indeed. But suffering from depression may happen later. The genesis of it may come sooner. What be the genesis must be the question, not the symptom that one suffers from. I believe the genesis of it is essentially this child caught in between a tug of war in which he will not do. And at that point in time, to stand up for the honor of the mother, which is, I believe, honorable thing and a courageous thing to do. and to be met with physical abuse in return, in my opinion.
We don't know. There's no material. Don't say anything based on your inferences and particular your. This is why the council is engaged, because you tend to then you are importing things, personal knowledge. What is, we may ask, what is the material to say on this? They don't say anything out of record. Yes, you have told us that, but this is as a fact, but the fact remains that he has not been convicted. Then this thing, your petition has been dismissed. What effect in law, we will have to consider.
I rely on the exhibits that I have produced for photograph of the injuries, the medical legal case that is registered, the opinion of the doctor. These are, I have tried to prove these allegations with an application.
Where are the photographs? Exhibit.
Exhibit P24 is a complaint. Exhibit P22 are the photographs. A series of 4 photographs.
Who has taken these photographs?
The mother has taken.
It's admitted by the other side. Then how it is proven? How?
I try to prove this by bringing the child to court, because after all this happened under the jurisdiction of the court at the first. While the magistrate's court, the magistrate's duty may be to prosecute and punish for certain action. The action of protection must first come from the family court.
We told you, I mean, we have, as we understand, you understand also the law. That's the problem of doing a 5-year law course. Right? You don't get to the point. Tell us, we have been repeatedly telling you that tell us 1, 2, 3, 4, 5 reasons why the children should continue in your custody. You this thing, start getting into this thing, something. You have told, again we are telling you, we have once repeated, again for your benefit we are repeating, that you have said you are a mother, daughter is of tender age, son can make an informed choice. He was subjected to this thing, physical torture, right? And then you have this thing admitted that he was suffering from depression. Your case is that he's suffering from depression because of respondent. Fine. We don't know. We will take into account the fact. What else? How he is suffering from depression because of respondent, therefore he should continue with you. That's the argument.
I'm taking it when he was in a position where he was trying to hurt himself.
So what is the submission? Eventually we will have that since he is suffering, your son is suffering from depression on account of respondent, therefore he should stay with you.
And during that time, I have been the one who has cared for him. I have been the one who has kept him safe. I have been the one who has consulted doctors, done those expenses. That has come to, that has fallen out. And there is no separation.
What else?
As the respondent said in such cases.
So he has not said anything. Yet to begin. Yes.
Physical custody and legal guardianship being distinct. Custody may very well be awarded to one parent. Legal guardianship may be awarded to another parent. Legal guardianship, on the other hand, entails larger sort of responsibilities, such as medical expenses and school fees. There has been a demonstrated disregard by the father to bear any expenses related to the children.
But he has not incurred any expenses.
In the last 1 year, absolutely not. In fact, before I sought this honorable court's permission, we need to relocate to Delhi, where my parents reside.
So the court said 10 lakhs. He deposited. You didn't deposit 10 lakhs. You are free to relocate the children to Delhi. Why you didn't go?
At that point in time, the question was placed to me.
Please, you should appreciate. Don't get into the effect of interim orders that will be subsequent. What is the effect of non-compliance? But now, right now, you are telling us the grounds why, how the welfare of the children would be well served if they are in your custody. They are deciding this issue finally. He did not do that. He did not we will issue direction that if he is not bearing the expenses, he will have to bear expenses. But that nothing turns upon that. Not bearing means what?
Now by us. So what were the children insofar as continuity of education is concerned, insofar as their day-to-day expenses of food and recreation are concerned, psychological aids for their education and education, all is provided by the mother through the support of the parents.
He has not paid any amount.
The last 1 year, absolutely
Not well. Before that,
he was paying school fees only and all other expenses by the mother. But allegations have been made against the mother regarding her infidelity and unfaithfulness. The allegations also lie against the father regarding his.
we don't.
I mean, I am urging. That's what is not really adjudicated has overruled all evidence that was presented in this.
No, Mr. You are admitting this fact that the decree for divorce has been granted on the ground of cruelty and adultery. You don't have any source of think that you are 12th standard pass. The admitted facts in this proceeding, we are not going to give any character certificate or he is good. Nothing of that sort. But again, we were reminding you of the appeal is confined. So,
It was one of the grounds that I had urged in my petition.
so can you raise this ground that she is not of good character?
Adjudicated upon by the lower court in any way, my lord. It is essentially a qualitative analysis between the father and the mother.
You don't know, really don't know how, whether you can, we are asking you, can you raise this that he doesn't have a good character in an appeal seeking custody?
I would hesitate because in the defense of the
We are only asking so that we can record. If you raise it, we will reject it. We will have to, but we will have to record and then assign reason that this is character of this thing responded, and there is no adjudication, right? What is the evidence which you have led that he doesn't have a good character? How does it have a bearing on the child?
I have produced exhibits P5, 6, 7, 8, P5 to 8. These are photographs that were taken of the father here in Bangalore, and he checked into.
So has it been proved? Then what are the Mr. There you should understand that marking of exhibits I may 100 exhibits. I have to prove it in accordance with law. Don't say anything. Anything which you are, there is no evidence.
My grievance, my lord, before insofar as the procedure adopted before the trial court was that I sought to examine the minor child as a witness in order to prove the allegations of abuse. Opportunity was not granted. I also sought to examine certain other witnesses in order to prove the allegations of adultery against the father, and that opportunity was also not granted. Whereas a similar opportunity was granted to the father to some parents and managers, etc. That opportunity is denied.
I mean, you will have to. How many years of practice, Mr. 10 months? 10 years. Oh, trial stage, right? So, you should understand, right? I mean, you are making submissions like in thin air. When did you ask for an opportunity? When family court rejected? What happened? All this has to be told. You are just without reference to record. We are sorry that we will not do this homework. We will say that he made a submission without substantiating it. You are just casually addressing as if, I mean, it's our job to go through the record and to find out that opportunity has been given. When you pray for an opportunity, when it has been rejected, how family court order sheets you have?
I wish I was able to access the honorable court a little bit better. My copy applications have been pending for 2 months and I have not received any papers. And I tried to follow up exhibits, order sheets. I've gone there 4 or 5 times.
So we will, in the absence of this thing, we will have to say that you have not been able to substantiate. We will not do it. This is not the work of the business. You are here to assist us, not to make our life difficult. And we will not entertain this. You have, without reference to any dates, you have said that you have been denied opportunity. We will say that you have not been able to substantiate this. Fine. So this is the, you can go through the record. There is nothing. There is a way to argue, right? You are just like a moot court competition. This is court. You cannot get away by saying something off the record without, you have not even referred to the verge of conclusion. You have not even read the judgment. Why custody has been granted? You have not assailed the findings of the family court. Perhaps we cannot tell you how to argue. So your choice is yours. There's nothing learned. But as far as the judgment goes, at least which is laid out by the High Court. So that's it. Why the custody should be granted to you? That's it. Summarize. Fine. Now, fine. That we have noted. The older child is able to make an intelligent reference. Yes. That the allegations of abuse that perhaps have swayed the older child to make this. What is the law? What is the law with regard to wish of a minor child? Custody matters. It is one of the factors to be taken into account, not the sole thing. So we cannot say that he can make an intelligent choice, therefore let him choose. So it would have been so easy, right? All appeals within 3 minutes we could have disposed of. All the children, yes, where do you want to stay? So they will say with the mother. In whose custody they are, they will say. So we would have disposed of. Children have said they want to live with the respondent, therefore dismiss. The law. Unfortunately, we have to write. On these grounds, I expect the welfare of the children has been safeguarded by the mother during the entire time the children have been with her. Yes. I don't have any further arguments. My lord asked for point by point arguments. These are my point by point arguments. No, point by point. Hello, please appreciate this, that you have filed an appeal against that judgment. You have not assailed that judgment on any point. You will have to assail the finding recorded by the family court. You have not read the judgment. You have not told us why custody has been granted to respondent. We will take it that we will be really serious in writing that he has not told us what ground the application has been allowed, not assailed the finding. What? That is the judgment. Yes. Yes.
Paragraph number 39. It's 73. The trial court observes the petitioner has filed a petition in sole custody of the children. Take away from the respondent and the party. No independent source of income to maintain a minor children. It has to depend on the parents. The children are studying in a good school, and the respondent is staying school. Only legal obligation of the respondent father to maintain the minor children might be the petitioner has heard that she is best suited for the minor children and the children love to live. There is no doubt the children are to be in the care and protection of the mother, and the father's role in upbringing the children cannot be. If it is placed by the petitioner on record, is not sufficient to establish that the respondent has acted because she is not a fit person to be appointed as guardian. The assault of the minor child in the complaint is registered against the respondent father and his family member. Is pending before the competent court as the petitioner intends to challenge. There is no grave danger from the father to the life and limb of a minor child. Recently, in winter vacation, the children were with the father and his photographs were produced. They appear to be happy and there is no complaint. The petitioner has made complaints against the respondent and his family members and acted an alleged act of ill treatment by them against her without any evidence. There are contradictions in the petitioner's pleadings. Evidence based on record, especially in regards to the allegations of harassment and dowry demand. The conduct of the petitioner is not conducive to promote the welfare of the children, which is the sole criterion to be considered in matters relating to custody. Evidence of the petitioner is inconsistent and not supported by acceptable material. The atmosphere that the petitioner is living alone, without any support from her family, is not suitable, and the children cannot be safe and secure. Therefore, she is disentitled from claiming guardianship and permanent custody of the minor children. Furthermore, in paragraph 40, the High Court says the respondent father is a natural guardian of the minor children. He is a graduate and well settled in Bangalore and has good financial resources. The respondent is living with his mother, who is an elderly person affectionate to the grandchildren, and the respondent is having his elder brother and his family. The children were born in Bangalore and brought up in joint family. Will have a the girl child Parini is aged about 6 years, and she is the only girl child in their family. The petitioner has the matrimonial law without giving any explanation to the respondent. Separately from the respondent, it is not justified. If the petitioner is appointed as sole guardian, it affects the interest of the minor children, and she is living alone in an apartment without family support. The respondent father has been accompanied by his entire family. The petitioner has appeared alone. She has neither been accompanied by anyone from the family nor any evidence produced in this regard. Therefore, the petitioner mother is not entitled to custody of the minor children. She cannot be appointed as guardian to personal property. The petitioner has not placed any record in respect of her educational qualification and her financial capacity. The respondent is having his family business and is financially fit to provide good education. Added to this, he is living in a joint family and having family support. The petitioner's parents are in Delhi. She is not having a close relative at Bangalore except her cousin brother who stays at Yelahanka with his family. The only support to the petitioner is a maid servant who is available from 9 a.m. to 12 noon. The respondent is in an advantageous position living in a joint family. The respondent father is a suitable person to take care of the minor children. Therefore, he is entitled to permanent custody of the minor children. However, the petitioner mother is at liberty to have access to the children by giving rights to her. Therefore, I conclude that the respondent father, who is natural guardian, is entitled to the custody of the minor children. The request of the petitioner mother for full guardianship and permanent custody. grievance against the observations in these two paragraphs. At the very first instance, it is noted by the trial court that the father is the natural guardian of the children, as is the mother. Like the natural guardianship of both parents is on equal footing, neither one being greater nor the other. So the observation of the court that the father is the natural guardian of the child is also liable to be countered by the fact so is the mother, and the law does not make a preference that the father shall come first. The second being that there is a qualitative analysis of the merits and demerits of their status, their education, their finances, their families. And in this regard, my lord, my humble submission is that in a country like India, where primarily barring the state of Meghalaya, it is usually marriage, the wife that leaves her parental and thereafter either shifts to the residence of the husband or they're separated. In almost every case, the wife will leave her parental. So should there be any take our marital discord, inevitably the wife having forgone her previous family to become a part of this new family unit, any qualitative analysis will always say that the wife is alone in this city because she has left her parental home and come here to reside with the husband. That the support that the father enjoys here, which is a joint family, is because he has never had to leave the family in order to become a member of the family. That qualitative analysis between the two genders of which city they live in and who their family support are cannot be sustained because it would be disadvantageous to the woman in more cases than not.
What is the criteria according to you for judging the welfare of the child?
But this qualitative analysis.
What is the criteria then? If the status, financial resources, whatever cannot be taken into consideration, what else should be taken into consideration? Determine the. If your argument is accepted, the court should not compare the status, educational qualification, financial resources. How the court should decide the question of best interest of. What is the criteria?
Definitely financial resources, the ability to provide an education. I am not.
Just now you have argued to the contrary. It should not be done.
Qualitative analysis ought to be carried out. That cannot be the sole criteria to decide that the mother is disqualified. Because inevitably, the mother would have left her own parental home to situate to live in life. And despite my lower education, I am good enough to.
No, your parents could have shifted here. We don't know. We are not giving an answer to you. Fine, we will take it. Fine. The fact remains that you are living alone. That's it.
I was living alone. Lord, I may very well have remained in Delhi rather than come back to Bangalore and file an application over here and pay myself come within the jurisdiction of this honorable court. In most cases, when there is marital discord and there is a separation, the wife tends to go back to the parental home where there is support.
It's not the case.
It's not the case. My client
you have suffered an order.
Yes, my client willingly approached the trial court.
We don't know.
Come back to Bangalore, has filed a petition, has subjected herself to the jurisdiction of the court. Insofar as welfare is concerned, I believe that this qualitative analysis that the father has his family here, the father has education and business here. The mother, on the other hand, has no one here because she is from Delhi, she married and came over here. In my opinion, that I humbly would say that the trial court has taken a very patriarchal view of what the qualitative analysis should be. Rather, it should also be seen that for 4 years or 3 years during the pendency of the petition, the children were always in the care and custody of the mother. This aspect has not been taken care. Why should the care and custody of the mother be started by the trial court, then thereafter confirmed by the honorable court and not disturbed by the honorable court?
That is the interim order.
Yes. And
here against, please understand, this is a final order. What custody granted? Then why have you, if the custody has been granted to you, then why have you filed this appeal? If custody according to you has been granted by the family court, which has been affirmed by Supreme Court, then why have you filed this appeal? Please understand.
Is where are the children? Who is looking after them, etc. If I have to arrive at an order that says let me change the status quo, let the children go there, there must be compelling reasons for that status quo to change. That being my that for 3 years, the honorable court below this honorable court in its writ jurisdiction and as well as the apex court did not find it fit to interfere with the issue of custody with the mother.
That was an interim order.
All orders of guardianship and custody in a are by themselves temporary. If we depending on the welfare of the child. To this day, I believe that even if an order is passed, whether it be in his favor or my favor, if it be in the interest of the children, then it must be modified. I'm sure that this would take into note. So
And subsequent events, not the past. Yes. Subsequent events from the date of judgment if they arise. Here, don't dispute.
So that the analysis of the honorable court is confined only to this. That there is
So
absolutely
we asked you one question. You are defaults with the criteria evolved by the family court to assess with regard to the issue of best interest of the child. Then if it is wrong, then what should be the criteria? What according to you? Any case law, what case law you are relying?
case law.
What should be the criteria of determination of the issue of welfare of the child?
So the criteria for determination of welfare is laid out in section 17 as my lord already stated, that it will have due regard to gender of the child, age of the child, and thereafter the necessity of child of a sufficiently advanced age to the child's preferences. Facts, day-to-day events, I would say availability of a parent when the children are of a age would be my client being a homemaker is available to the needs of the children right from the moment they wake up to the moment they go to bed. Whether it is their early morning diet, whether it is their academic rigor, I am aware of all the subjects that they study. I am aware of how well they are doing. I am constantly making sure that they are taking their classes. And I would assume, of course, and I am open to being wrong, but the same level of availability and interest is missing in so far. As a businessman, is not available at home. So in his absence, of course, it will be the mother that will take care. And in the absence of the mother being in the house, the duty may very well fall on his mother to provide that kind of maternal support that the children need. At the very first instance, I believe availability of a parent is the number one thing that must be looked into. Is the parent available? Is the parent discharging his or her duties in a dutiful way? And is the parent aware of the intricacies of the needs of the child? Each child will have certain preferences there. You know what they like to eat, what they like to read, what they like to watch, who they like to talk to, what are their needs. My client has been with the children and been aware and has that maternal relationship with the children throughout all 16 years of maturity. Right? And all 9 years of the younger daughter Pariniti's life. My client being a homemaker and a stay-at-home mom has always been present in their needs. In the pendency of this appeal as well, it required emergency care and attention. And my client has proved that she was there at that point in time. The minor child was admitted at St. John's Hospital, Mangalore, and it enhanced. It is against their rules that a minor can stay there without supervision or without a guardian. So it was necessary for one guardian at least to remain there. It was my client who stayed both at Enhanced and at St. John's. It was the mother that stayed in the ward along with the child. 3 weeks, 4 weeks, while simultaneously managing the older child's emotional health and also keeping the younger child's spirits up and also ensuring that due regard is paid to her education because the older child had stopped taking classes. I think that sort of presence, availability, and unflinching care that she has provided to the children. That I believe that there is no material on record, there are no allegations. Of course, there are allegations against me insofar as I must ask. I can only seek shelter under this umbrella. I may be a terrible spouse, but that does not disqualify me from being a good parent to my children. So far as my children are concerned, I have been exemplary in the performance of my obligations towards them.
Yes. Yes. Which paragraph?
In paragraph number 11, the main thrust of arguments on behalf of
Which page? Right. This is submission.
page number 16. Paragraph number 11, let me take a note of my notes.
Point out what you want to. This is a submission made in that case. How does it help you? You have to, don't leave it to us, Mr. We are telling you. Please, I will don't pass on this compilation to us without telling us the paragraph. We will say that you have not. This is the submission of the appellant in that case. Page 29.
Page 29. Continuation of paragraph number 23. This page.
23.
Starts at page number 28. Edit method.
Oh, yes.
The approach of the family code, even as per the customary law and statutory law, the father is the natural guardian of the minor. Can the custody of the minor child be divested from the father, even in the absence of any disqualification on the part of the father to retain the custody of the child? In the normal course of events, this proposition certainly is a sound proposition. And in fact, when the father and mother are together, there is no conflict of interest between them. And more often than with the father being the supporting parent of the child and the family, the father inevitably is the natural guardian of the mother thereafter. Also, they follow guardianship as a matter of course. It is only when the parents are not seen eye to eye, when the parents are separated and there is conflict of interest between the two, question assumes importance. Custody need not follow guardianship in all cases. Section 13 of the Hindu Minority and Guardianship Act of 1956 makes it very clear that the paramount consideration in appointing any person as a guardian of the Hindu minor the welfare of the minor. Section 6 having spelled out who acts as a natural guardian. It is the father and mother in that order in the case of minor child. The person will be appointed or declared as a guardian of the child. She will have to be in a situation other than what is contemplated in disturbed by this, the parent has disqualified himself or herself, and unless it is found that it is not in the welfare or in the interest of the child to continue the guardianship with such parent, positive disqualification is a very essential requirement. If a parent is to be disentitled from guardianship of the minor, here on my lord, disqualification of the parent is not a very essential element to shift custody from a parent. I cite this, my lord, because although ordinarily I would be very happy for legal guardianship to continue to vest in the father, so that he may continue to enjoy certain rights and, of course, enjoy himself the duties of legal father. I made by the fact that in the last 1 year there has been no participation in facilities, which perhaps must be entrusted to legal guardianship. And this, unless there are circumstances that can be indicated as to why he has not done so, I believe an absence of participation, active participation, an absence of contribution towards the children's education, healthcare, day-to-day needs would inevitably indicate that there is no interest to share responsibility, and rather that the father is only interested in discharging responsibility should he also have custody. So I am quoting this that guardianship, although ordinarily I would be very happy for the father to enjoy so that the children may have a shade of his protection. In this case, by his own actions and inactions, the father may perhaps have rendered himself disqualified from being recognized to do that.
You have not read para 24. Please read it for your benefit.
Suggesting that the father, being the natural guardian of the child, as between the two parents, is the first person, is necessarily linked to the traditional concept and role of the father in the Hindu family. Traditionally and conventionally, only the male members of the fifth members of the family who is entrusted with the guardianship of a minor child should be both financially and physically capable of protecting the interest. This was always played by the father. The male was considered always superior both in his ability to earn the livelihood for the family and long way from this tradition. Gender equality is the accepted and developing trend, and financial independence is as much the domain of the female members of the family.
Para 27, in fact. 27, page 30. Analysis. Para 27.
The custody of the minor claim can only be the welfare of the child, and the rights of the parents has to be obviated. Very well established and recognized. So the concept of the father of a minor child is in a better or superior position to take care of the child as a modern parent is capable of taking care of the child. The question of custody will always be decided by taking into consideration facts in each case, ability of the parents to provide necessary facilities, environmental, companionship, love, and affection are all factors which courts have to bear in mind in deciding the question. The question is not viewed anymore from the angle of which parent has a better right, but from parents is better suited for the integrated development personality of the child. Whether the child receives the necessary inputs if it is in the company of a particular parent for a healthy growth and development of the personality of the child. In fact, as one could perceive, the child always needs the company of both parents for such growth and development. The child desires and yearns for the company of both parents. Unfortunately, in a situation where it becomes inevitable that the parents part company and live separately, I can have the company at time and not simultaneously. This is a situation brought about by the parents. Inevitably, the child is the victim, and whatever arrangement may be made either by the parties themselves or on their favor by the courts as ultimate guardian of the minor child, it will always fall short of satisfactory arrangement from the child's point of view, and the child does suffer. Therefore, the question is to be approached from the angle of mitigating the suffering, the hardship and psychological trauma that the child undergoes due to the separation of the parents. The harsh reality is that the parents can no more live together, particularly in a situation that is a conflict.
Read para 40. It's your judgment relied. We hope that you have read it. Para 40, page 15. 40.
But not need disqualification or drawbacks. The mother, on the other hand, well educated and can support financially. While the mother can keep full-time company with the child, the father child keep a female child of tender age. Companionship of the mother is a very valuable to the development of the child and its personality. There is a clear opinion that no child should be deprived the company of his or her mother unless there are compelling reasons and circumstances. So, in this case, we do not find any reason at all to deny the child greater companionship of the mother. We don't see compelling circumstances. And we have clear view that the child interests and welfare is best served and promoted by the child continuing in the company, care, and custody of the mother. He does not mean that the father should be deprived of the company of the child. The child can
Fine. So what we are trying to tell you is that this case also into account the education of the mother and her financial capacity to decide in favor of the mother. That's what para 40 says.
If there was a mutual consent understanding, we don't have which both parents were granted guardianship and custody of the child. 1 week alternative, 1 week with the mother and 1 week with the father. This dispute arose when the mother decided she wanted to change those terms and have sole custody of the child. So far as education are concerned, my lord, or financial capacity are concerned, all expenses relating to the children from the date of separation from the husband have been borne by. Sir, I may not have the income of my own employment today, but my parents have been a steadfast support. As paid by the other side, have not been abandoned by my family. My family has come to my aid and has given my support. The family that I was a part of. As far as finances are concerned, yes, I am not well-employed. I do not have a source of income. But I similarly to my husband or my ex, I too am part of a family that is in a similar line of business. They too are all in the iron and steel business, as is my family. I enjoy the goodwill and the support of my family. The children's schooling in 2 schools in Delhi and Gujarat is now being taken care of entirely by my parents. And so far as love and affection is concerned, care and concern is concerned, I would submit that my client has been there unfulfilled. And if any disqualification may be incurred by not having a source of income of her own, I urge this honorable to consider that though I may not be able to raise the money on my own, I certainly enjoy the support of my family, and after this honorable court has given me the permission to relocate to Delhi, my family that has supported me has been able to enjoy time with children. I do have parents, maternal grandparents. Maternal grandparents also have a right to spend quality time with their grandchild. And ever since the children have relocated to Delhi, their ties with their maternal grandparents have been very strong. My sister, my brother-in-law, with whom I am pledged to be in a relationship, they are also in Delhi. I enjoy cordial relations with them. When my son was hospitalized at St. John's Hospital, it was my mother and my sister who visited me, who spent time with me and my childhood. Argued that I am abandoned. I continue to enjoy this. To be my submission on the education and the income.
Is it that they visited and all this? There has to be evidence which you have to point out. You are just making submission.
These are things that have taken place during the pendency of this appeal, my lord. This appeal.
Where have you stated? Additional evidence. What?
My memorandum of appeal was in 2019, my lord. These incidents have taken place in 2021.
Please understand, this is an appeal. You cannot just make statement and get away. It's not a original proceeding under Article 226 where you can get away. There's no evidence, so that's what we are going to say. You argue anything. What is it? They came, they support you, they came, state. Where is it? It's all submission. Without what is the evidence? You will have to substantiate it with reference to evidence. All you had come to the case law citation. You have cited the first decision. Then you are going to deposition. We don't think that we should tell you how to argue an appeal. Yes. Two and three are not relying, right? Not relying.
I'm thinking because of the case of the father against me. Finally, about the allegations of bribery.
It's a single bench, right? You should know whether it's appropriate to cite single bench decision before DB without seeking leave of the court, without mentioning. All right, go ahead. in favor of the management fact. 39. Yes. Capital report to be made of the observation of achieving the management. According to this, the modern basis is the breakup of the management not provide the necessary physical and emotional environment, not provide. That's it. That's why we asked you in the beginning itself the reasons. It is in the best interest of the children to continue with you. That was the purpose. This question, any number of authorities you may cite. The only thing is off-quoted, and this thing need not. This thing is to be reiterated that welfare of the child, it has to be decided in the facts of each case. That's it. Every decision will end at that only. This question has to be decided in the facts of this case. Yes. Next. Hey, please read. Don't. Like this, like this, we appear to be that there is no reason at all why the mother ought not to have carried into the children. Can you put it to her and she is attached? Has he remarried? It does not apply. That is the distinguishing feature. Remarriage is a factor to be taken into account. He has not remarried. Obviously. The partner is taken, will have children. The father has one child from the second marriage, but unfortunately, not just on that ground, for the mother. This must inevitably happen when a mother, not necessarily the father will only leave for the unhappiness. And two like of operating defense. Founding this the mother that she should remain there and control the children. I think that the error was in the balance. Every involved balancing choices in this. In this government award, mother, sir, and
In page number 64, my lord. No. That I put in
Which paragraph?
For this, I would like to kind of tell you paragraph number 12.
What is the authority? You are relying on this.
My lord, in this, in number 12, may I read the lines that I'm reading on? Like, for to point out that both these children have been in the if no complaint is made by the father that he will not do any proper education or proper health on this. It was repeatedly continued by the husband side that it is in a better position to provide financial support to children. The boy was higher threatened, high financial support was required. The mother was employed as chief under SCI and they only to provide financial support. And as per the evidence, the apparent wife remained unemployed. And it has also reported that the amount of the children are living under support. The court is unable to agree with this content. So that he is in a managerial capacity of the bank. They have good salary. That he might be in a better position to provide financial support to the children, and he could also provide a comfortable living to the children. It is also evidence that the father is a tennis player and during a short period of stay of the children. All these in the opinion of this court will not suffice, and that might be one of the relevant considerations, but cannot determine in fact custody of the minor. If the children are cannot take this benefit, there can be a flow of finance which can give only a comfort physically, but not mentally. The welfare of the minor child has to be considered by the background of the relevant facts. Case of got to be decided on the facts, and the court should exercise a judicial respect in the background of all relevant facts. At the same time, the financial resources. I think my lord was taken shop. Finally, Chetana Ramkita to speak about this qualification. Financial resources alone not be full practical. The reports by counselors of those easily and even do that. That's all. The two children, the son was born on 11/9/2006. The daughter was born on 12th of March 2015. So until 23rd of May 2016, admittedly there was no dispute in the parties. There was regular hearing, there was marriage. There was no dispute against for any court. They were together in the same joint family.
Till 23rd.
2016. So that day, Lord, the husband discovers that the wife has another mobile instrument which is unaware of, a second mobile phone. Discovering that mobile phone, immediately she calls the brother in Delhi and deals with the children on 25th of May 2016. She leaves for Delhi. 25-5. So, the family have a lot of discussion between 25-5 and 16. On 6/6/2016, the husband and his mother are attending a wedding in Chennai, at which time the husband receives a call from the appearance that his brother-in-law, his wife's brother, that she has left Delhi along with the children that are coming to Bangalore. She comes to Bangalore, I'm not in town, I'm only away from Chennai by train. And she goes busy. The next morning, her father and brother come to Bangalore on 7/6/16 and file a missing complaint at the Cathedral at the Bangalore area. And FIR is registered. And they finally place her on the family court, where she has presented a petition for custody. And the entire family, the husband, the father-in-law, the wife's brother-in-law, and her father-in-law within the family court. And Indian law is part of the family court, the husband should not take custody. The next day, she files an apology letter before the police station and files an apology that I'm sorry to inform my parents that I get missing. The family, only these are facts, we did for the family court and records about evidence that we So a joint family meeting is held in Bangalore, where she admits in front of all the family members that she's in a relationship with her sister. The recording.
Very good. Which exhibit?
Yes, data transcript and details of record. P58. Exhibit P58. Also, her attempts to commit suicide with medical records are produced. Complaints filed by her father and brother.
Which is that exhibit? Have to commit suicide. What are the documents?
Yes. Those are exhibits are 12-13, are 13,
are 12,
12 and 13, are 20, 21, 22, 23, 24, and 25.
Just a minute. Are 20,
20 to 25.
20 to 25.
Yes.
These documents.
Are 12 and 13 are the completed FIR lodged by the appellant's brother that she has gone missing after coming to Bangalore. So her irresponsibility, she had minus.
You said that you are relying on these documents to show that she attempted to commit suicide.
I'm not making the note. She attended suicide, she attended to hospital.
It is R20.
The letter issued by the Narayana Multi-Specialty Hospital issued on 21/4/2015. Accidentally at the time, there was no dispute between the parties.
So has it been proved?
And there was a document accepted, and the judgment is also takes into account that these documents have been proved in the regulations. But
Exhibit R20.
So, what's the meaning? In line with what the family could have prepared.
Yeah. Which page? Exhibit P20. Please tell us. R20. Which page of the paper? Page number 27. P27. One minute. Yes. 21/4/2015. Hospital with self-cover. Female was brought to Manara Medical Hospital, alleged history of self-consumption of tablets and taking number. Alleged history of patient having taken tablets and AA following which she was taken to local hospital and CPR initiated. When brought to so here, so what was not given. Patient uncooperated, vomiting malaria disorder. Patient attended refused MLC and further evaluation and management. Because they were living together in the same house. We don't want any business case in this and my wife wants to go criminal proceedings. Therefore, we cannot just we request the hospital not to report the matter to the police. But the receipt, the bill is on the next page 328. So what you want to say that she is of unstable mind? She undergone counseling and treatment on page 333, exhibit R23. 333. A week after the incident, she was. Fiction, right? It's a relevant treatment professional. From the page 334 onward, all the consultation, the treatment is undergone. This is for consultation. R26 is the next document, page 336. Letter written by P3. R26. People who have authored this letter are Govind Ram Goyal and Nitin Goyal. These are the father and brother of the applicant for your questions. Regarding the suicidal tendency. With regard to the above said subject matter, we would like to respectfully submit as follows. Both of us are permanent residents of New Delhi as mentioned above and acting temporarily at my daughter and son-in-law's house at Solanpur. My daughter Sakshi, age of 21 years, is married to son of so and so for the past 10 years and is residing at Solanpur. The wedding had taken place on 15/7/2005 in Bangalore. My daughter is happily married to and is having 2 children. One son is about 8 years old and one daughter is about 2 years old. For some time, my daughter is suffering from a mental disorder and has attempted suicide on various occasions in the past. I will submit respectfully before your good self. The family of my son-in-law is very nice and well behaved. We have never had any problem with any man in the past. Sir, my daughter has a mental disorder and they are helping her in getting medical treatment. I respectfully submit that my son-in-law and his entire family should not be held
There is no reason to blame them. In the event when an unfortunate incident occurs, my daughter's action victim will be solely responsible for the same. The statement is given by a voluntarily and is beyond the ridiculous to the resort. I hereby request to kindly acknowledge the receipt. Dated 14th July 2015. Absolutely no difference between the party for the same. Admittedly no difference between the party for the same. The same day, the husband also filed intimation with the police in similar terms at Exhibit R27. At that point in time, I'm aware the reason behind these attempts from her. These dates coincide with the dates she has fought with her mother-in-law. So we will go to place on record. From 13/7. 27 is the intimation. On 13/7, she puts up a WhatsApp status on her mobile phone with her news tied to a fan.
Oh.
So her mother-in-law can see that picture. Has a WhatsApp profile as a status on the WhatsApp. And the document also produced at Exhibit R54, page number 428. And you see the date of the intimation by the father and the husband is on 14/7. On 13/7 is the photograph.
Page
438. Left-hand side photo, there are two photographs.
.38.
It's like 2015. On the left-hand side. This is a picture here of WhatsApp.
This is the picture.
Of a news.
Yes. Yes. Yes, but
it's live news. To a fan.
Yes.
And that tendency that concern attempts to commit suicide with no role that I have played in those attempts. It is not that I had harassed her or repeated her because of which she made those attempts. The parents of themselves come before the police and said that I have always treated her well. My entire family has taken care of her properly.
She told us that she also admitted about this, which document?
In the petition. In the petition, but the narrative she gives in the petition, the reason for suicide is they were not allowing me to start a business. I wanted to start a business of my own.
She admitted that she was having a affair with whatever relation.
Yes, sir. Yes, yes.
In front of family members,
yes,
which you said there are documents.
Exhibit P58, that is volume number 2 of volume 3.
Page.
Page number 812, 512, 502.
Don't be in a hurry, Mr. Be in a hurry to conclude. So we have to see the pages, and if we don't find an exhibit,
512,
512 is some sort of a question.
It's a conversation between the husband and the wife.
What is conversation? WhatsApp?
Telephone recorded conversation. The original telephone was played before the court, and the entire conversation was transcribed in the typed copy of the conversation. This is
the recorded conversation.
It's about 12 lines from the top of the page. He says, "Do people share dash photographs?" He said, "Yes." So 12 lines from the top of the page. There was a photograph for exchange.
Yes. Yes.
Also, page 509, go back to page 509. In the entire conversation where she admits that there was a physical relationship between her and her brother-in-law.
Which page?
509.
All before the trial court, family court, right?
It's all admitted
What is the exhibit?
P58. Sorry, R58.
R50. Page 509.
When the trial court has numbered both sheets at one page, therefore the second sheet of page 509. What instigated people towards sex? What is the time? Nothing is instigated us. I was in similar discussion I did last year's thing. When was the incident? This is last year's thing. Last year's incident, last year's June.
Yes.
Yes.
At the bottom of the page, the relevant mentioned about her character as a person with a third party will not affect her suitability to have custody of the children. Kindly see the bottom 4 lines. This was in the presence of the children. The children were present in the same room. Same page, last 4 lines. And she said it's a voluntary, the next page, the second line. The husband asked the wife, when she told she said no, there was no force. Next page was the second line. The first question he asked is, was there any force? I would say.
Did you push it?
No, not like this. Listen to this.
And the page is here.
Shade is missing.
In 127. Yes.
That's the problem. That's why we say that you please tell us. You will find out. We will say that on this page, you will obviously not find it out. That's why we are. Where do you this thing? The children were present.
Not at page 509. Turn the page over, the last 4 lines on the left hand side. Carry over.
Okay. My kids were there.
Yes, they were speaking there. What was the way of doing this? And the family could has cut out this part where the children were present and said, this is not just a person who's involved, it's a person who's absolutely irresponsible, who has no concern for children's well-being.
Just it will be
Because of 590.
Like 90.
90. Sorry, page 588. 588. In line with the bottom, what record is the timing will also include hotel record where both the applicant and the cousin have stayed or spent time together. Therefore, they have taken pictures of the hotels. The husband asked them, how did the photographs land on your phone with the hotel room in the background? When did you get this iPhone? How did this pic end up in your phone? It has been over 1.5 years. How did you get these photos? He has been sending photos of whenever he traveled, even when he traveled to also he sent photos. While looking at those, only look at it so no one could look at it. And then you start getting higher incident things, you start enjoying.
Right, that's yes, all this. He did not going to have fine that.
But the other documents that have been placed on record to support the allegation of identity provided. An application was filed to summon record.
This is admitted, right? This is admitted by the appellant that the marriage has been dissolved on the ground of adultery. It has not been challenged. He need not go into details. Your submission is that adulterous conduct on the part of is entitled sir for custody of the children.
This is some strange and unknown person could have been overlooked weighing children's welfare. This is her own sister's husband. A person who is so reckless and negligent, she does not even care for not just her family, even her sister's family. It's a person who doesn't mind taking dangerous risks. And second, children's presence. Such a person, in my humble submission, does not have a children's welfare. Four documents, not exhibits.
Which page?
The first page. Page 262.
262.
The first page.
Letter of authorization.
From the hotel where the appellant is a brother-in-law and stayed. Along with page 264, the ID card has worked. And it proves that given to the hotel and checking it. The respondent was refused to identify her passport. In the examination,
What do you want to say? I mean,
that both of them have stayed in the hotel together. That was the question about it. So she has no respect for judicial process. She has filed 4 false cases against me. One was a 498 complaint which has been quashed in the dismissal court. Subsequent to the disposal of the custody case.
when it was filed, where it was actually tell us.
The complaint was filed on 2017. 2017. 498 against the husband, mother-in-law, brother-in-law, and brother-in-law. It was quashed by the court before. The next one was a complaint she filed on 11/2/2017, and FIR was registered against the husband and the husband's brother. On the allegation that some unknown person assaulted her in Indranagar, the house in HSR layout, 15 kilometers away. She was going to visit the temple in Indranagar. She was assaulted on 3/2/2017. On 3rd of February 2017, she was assaulted, and the complaint is filed on 11/2/2017. The reason given for lodging the complaint 8 days later is that she was very badly assaulted, brutally assaulted, and she could not move out of her bed. That is not exhibit R15.
What is, yes. What is, I mean, the submission so far you have made is with regard to her adulterous behavior. Therefore, I mean, she's reckless, I mean, this thing, whatever. So therefore, she is not entitled to have custody.
Yes.
Conduct this entitled. Yes. Secondly, mentally unstable. Suicidal tendency. Therefore, she is not disqualified from having the custody. Yes. That's what you say.
That she has no respect for law and does not think twice before abusing the process of law. Such a person will not be a role model to the children. R15 is a complaint filed on 11/2017. In reference to an alleged incident that has taken place on 3/2/2017. The reason given to the complaint is I was physically incapacitated from moving out of my bed, and therefore I have not filed a complaint before. So kindly produce the order of the family court 6/2/2017. She is physically present before the family court on that day. The family court records her presence.
The complaint, it is stated that
The complaint is stated. The reason of filing this complaint related of 8 days is I was physically unable to come to the police station because I was badly injured. I have not been able to move on. On 6/2/2017, the family court records her presence as part of the order sheet. The complaint also the police have filed a B report that has become fine. It has not been signed. So far as the son assault is concerned, my respectful submission, that is also a case that was foisted against the husband and the family members. Reason is this one.
have we have his son himself made a complaint?
Yes.
While he was in your custody?
Yes. Yes. Sorry, the complaint was the son and daughter both were in my custody. The respondent filed an interim application before the family court seeking visitation during Diwali of 2017. The family court passed an order on 16/10/2017 granting her interim custody from 10 a.m. to 7 p.m. on 18/10, from 9 a.m. to 1 p.m.
Yes. So,
the order of the family court on an application filed by the mother.
Then
is the date of the order
17.
Where
do we get this order?
Page number 1, page 20.
What?
Page number?
Page number 20. The application I-70 filed by the petitioner that is in multiple PPC hereby allowed. The petitioner is given interim custody of the minor child, Master Lakshmithan and Kumari Parinthi Mittal, on 18/10/2017 from 9 a.m. to 7 p.m., on 19/10/2017 from 9 a.m. to 2 p.m., and on 20/10/2017 between 10 a.m. and 7 p.m.
Yes. 19/10.
18/10, 9 a.m. to 7 p.m. Kindly see the date of the complaint side. Exhibit R15. Exhibit P24. It is dated on 20th of October 2017. the last day of visitation, she had no intention of to send the child back or both the children back.
Complaint made by the son, right?
The son said in the complaint, my mother has taken me to the hospital, got a medical certificate, and now I have to file the complaint. But at that time, the son was about 10 years old, 11 years old. Can you appreciate the 11-year-old boy?
Which page? Page.
Yes. Which page number 219?
Second one.
The first one. We can get permission.
Yes.
But by my father and his brother and by my grandmother. Respected sir, yesterday, 1910, when I went back from my mother's home at 2 p.m., as per the court orders at my father's place, in the evening, after doing Diwali Puja at father's place, my grandmother started abusing my mother. I told her not to use abusive language for my mother. My father, his brother, my grandmother, they all locked me inside the room and they all beat me. I got hurt and got bruised on my nose, lips, and face. Today at 10 a.m., I came to my mother's place as per the court orders and told her about the incident. She then took me to Greenview Hospital, and where I was, kindly help me and do the meeting. There is no admission on the part of the father that the incident has taken place. Let us assume for a moment that the incident has taken place. No, a mother who takes a 11-year-old boy to a police station to file a complaint against his father, whether such a person should be interested in custody of the children. Her conduct will not belie her nature. Let us assume for a moment that this is true. Kindly see the timing of your complaint. 18th, 19th, 20th are the 3 days she has got visitation for the first time. Unsupervised visitation. Before that, her visitation was the mediation center of the family. The family control after going through her, because the records had been summoned by the hotel. Her medical records also were placed before the honorable court. Therefore, the only visitation she had until Diwali of 2017 was supervised visitation in the High Court Mediation Center. This complaint has been held to be false, and that finding has become final. The court has accepted the report filed by the police, and no revision has filed, and it has been filed again. 498 would have been what I will furnish a copy of the judgment of the report. The other complaint, the police station of assault, and also has been filed and has become final. What about her tendency to lie before court? I think she has no respect to judicial proceedings. In the petition she has filed before the family court, she mentions that I want to start a business. My husband and family members do not support me. Therefore, I was frustrated. I tried to commit suicide.
I mean, yes. Either she has not been a good mother, or she is not a fit person with whom the children looking after, right? For 2-3 years, the children are with the mother only.
Yes.
Right?
As long as the children were in my custody and they were in our joint custody until 2016, and thereafter in my individual custody, both the children were absolutely fine. So,
we want to see the photographs with the children.
I produced I have placed on record an exhibit. R1 choosing the pendency of the petition before the family court after the children went back to the mother. I have placed. I exhibit R17, the color photograph are part of the record. That should be
R17.
R17.
Page.
I have to do the photocopy, page 295, the entire joint family.
Volume 1, Volume 2.
85. Yes, you actually have the benefit of the color pictures based on the family code. That's part of the record. But all these pictures are with the joint. Yes. 85 pictures are produced. 85 pictures. That is to be accurate.
Exhibit R. 70 pieces.
Yes.
Yes.
That is when the children were living with the father after mother had left.
Photographs of which date? When?
While having lived together, that was reaching what point of time.
You're not asking the exact birth date. From
the birth of the children until
they are all grown up, right? Oh, initially, I mean, there is a baby.
Yes.
What is the CV?
Exhibit R18.
R18, what is CV?
That with the older, since they were digital printouts, the 65 year evidence act producing an electronic copy of the electronic document. I mentioned that she had no respect for law. Think twice before lying before the court, making false statements on law. But the entire petition, she said she tried to commit suicide. In the evidence affidavit she has filed, there is no whisper about that. In the petition that she has filed for custody note, she alleges that the husband and family have been ill-treating her. In the evidence note, for the first time, after the husband responds to her petition with an allegation of adultery against her, in the evidence for the first time, she makes an allegation of adultery against him with no foundation in case. There is not even an amendment of the petition that she made for the family. And that's not the family court. Her allegation to be untrue and my allegation to be not found correct.
I think read out paragraph. Whatever.
Paragraph 25, I invite you. Paragraph 25 was petition. The evidence, yes.
You want to refer anything, please.
Yes, sir. Page number 125 of volume number 1, this is the petition.
125.
Volume number 1.
Volume 1 and
only what we are
Page number 127.
what is it?
She has made an allegation. This is something that she made an allegation that the husband has forcibly got a fetus aborted. Case medical advice. But I'm only getting to a lordship the inconsistencies in her case, how false statements have been made on her, and they have been falsified in her cross-examination. Have you argued all this? Yes. Yes.
Where, where are you going to get all case, where have you?
Okay. False case will be.
So, this false statement and all.
So, we pay this to this. Very whether she aborted the child on her own or in forced in a petition because maybe you are too far to very yes. Okay. Section 70 of the Guardian and Wards Act. So the factors that should fall for consideration before the court that is called about to decide custody of children. Yes. In appointing or declaring the guardian of the minor, the court shall, subject to the provisions of this section, be guided by what consistently with the law to which the minor is subject appears in the circumstances to be for the welfare of the minor. In considering what will be for the welfare of the minor, the court shall have regard to the age, sex, and religion of the minor, the character and capacity of the proposed guardian, and his nearness to the kin of the minor, the wishes to gain of a deceased parent, and any existing or previous relation of the proposed guardian with the minor of the property. So the language used in subsection 2 is the court shall have regard to these factors. So subsection 3, if the minor is old enough to form an intelligent preference, the court may consider the preference. And the lordship rightly approved, 15-year-old boy cannot decide now what his future should be. But very well to understand to say now the father does not want to stay with the father. Kindly see, I may have stated now to the judgment of the family. I have 25. You pay 52 FP. The appeal paper. Another page for you. I have 25. Yes.
Indeed.
I have gone through the entire evidence on record and the arguments advanced by the relevant counsel on both sides. I have applied my mind to the allegations made to the petitioner and the allegations made to the respondent in taking custody of the minor children. I have reviewed the evidence of the parties for the rival claims. It is pertinent to note that the petitioner and the respondent got married in the year 2005. They did marital life, and from the lawful marriage, the petitioner gave birth to a son and a daughter, Lakshmi and Pariniti. The relationship was strained after the respondent came to know about the illicit relationship with one Rakesh Gupta from the mobile phone of the petitioner, which she had kept secretly in the year 2016. And she had not given proper explanation, and he found that the petitioner has developed illicit relationship with her own sister's husband. The petitioner has denied the allegations of adultery made against her. She has alleged that the respondent is in the habit of visiting other women for physical relationship. The family appeal was voluntary to the family of her sister and brother-in-law, informed her that the respondent is having so-and-so, but to be careful about him. But para 27. The respondent has filed MC 2536 of 2016 for divorce on the ground of adultery and cruelty against the petitioner here. In a statement of objection and counter petition, he has made a serious allegation of adultery against his wife and her brother-in-law, Rakesh Gupta. The present petitioner has not filed objection to the 171 of 2015. As far as the allegations of adultery made by the respondent against the petitioner requires a strict standard of proof, adultery destroys the basis of the family and it works against the interests of the children. In this connection, the respondent with evidence affidavit has sworn to the fact that the petitioner is living in adultery and in support thereof, he examined the staff of the hotel where the petitioner and the said Rakesh Gupta spent time in these locations. The hotel records and exhibits R61 to 69 pertaining to double tree speech by Hilton, Raj Airport, Bangalore, and Royal Senate was summoned by the auditor 31/1/2017. The petitioner and Rakesh Gupta have submitted their ID proof for staying in the above hotels. In the course of cross-examination, she denied and refused to identify the copy of her passport and the ID proof of Mr. Rakesh Gupta. The respondent has relied on the WhatsApp chats between the petitioner and Rakesh Gupta and various voice recordings. The respondent has placed a Xiaomi phone, Samsung phone, and Nokia phone marked in exhibit R60. According to the respondent, he has made a recording of the phone and voice conversation that has been transformed and transcribed to a compact disc at exhibit R57 and transcription exhibit R58 and 59. I have gone through the entire transcript produced on record. The text of more than 300 pages at exhibit R58. The relevant page is page 284, bottom line, and starting of 285. The petitioner accepted that Rakesh for the second time came in March 2016 to Taj Bangalore. Relevant portion is under. So you and Rakesh had text only once. No, he had come to Bangalore second time in March. We went at Taj near the airport. I had said, I'm going to friends' place for lunch. You went alone. Me and Pari, I and Rakesh had flown, so I stayed there for 2.5 hours. Pari was sleeping. You guys did it in front of her. Yes, if you were guilty the first time, why did you do it for the second time? It just happened. I don't know how and why, but it did happen. The respondent has also produced the statement of objection filed by Rakesh Gupta in NC 2536, wherein he states that there is a sacred relationship of brother and sister, relationship between him and the petitioner. The statement cannot be accepted in view of the evidence of record. The relationship cannot be termed as brother and sister. It is very clearly evident that the petitioner's parents and brother are very much aware of the illicit relationship between the petitioner and the said Rakesh Gupta, and they have advised her not to accept and confess. The material placed with the respondent is sufficient that there is an extramarital relationship between the petitioner and the Rakesh Gupta. But in her counter allegation, that the court says there is no evidence. From the second allegation, page para 31. Secondly, there is an allegation against the petitioner that she suffers from suicidal tendency. In this regard, the respondent has produced the discharge summary and the bills of Narayana Multi-Speciality Hospital by exhibits R20 to 22 and the prescription from Queen's Hospital R23, consultation bills R24, and profile of Dr. So-and-so. The respondent is led on the letter dated 14/7/2015 exhibit R26, submitted by the petitioner's father and brother to the Madiwala police station, indicating about the attempt to commit suicide and absconding. The respondent and family members are not responsible for any wrongdoing. Admittedly, this document exhibits R20 to R24 are from a time. The petitioner has denied the evidence by the respondent relating to her suicidal tendency. Besides, she has stated in her petition that she attempted to commit suicide, where in cross-examination she has denied ever attempting suicide. This evidence clearly indicates that the petitioner has been attempted earlier in her life. But in 37. The defendant has made allegations against the petitioner that she is involved with extramarital relationship with her brother-in-law, and they have spent time together on many occasions, more particularly in Bangalore, and she has left the matrimonial home on the abolition. On account of the illicit relationship, the family life is disturbed. I have examined the evidence relating to the allegations made by him. The court has summoned the records from the concerned hotel, and hotel staff are examined in this case and exhibit responding witnesses 2 to Article 4. The documents summoned by the court are placed on record. The copy of the ID card submitted by checking to the group is denied by the petitioner in the course of a cross-examination. The electronic evidence based on the respondent record also reveals that the couple engaged in conversation, and she admits about the extramarital relationship. Respondent against the petitioner wife probabilizes that there is an extramarital relationship between the petitioner and the brother-in-law. It is a cause for matrimonial dispute with the parties. In this connection, MC 2536 is filed by the respondent, same is pending. The respondent also stated the petitioner has suicidal tendencies and she attempted to commit suicide with a violent tomorrow. Yes. My lords, remaining matters, my lords.
Tomorrow, Mr. Kulkarni.
Interim orders may have to be continued, no?
Yes.
Please, 73.
Yes.
My lord, may I make a submission, my lord?
Tomorrow
Serial
make
number
a submission.
71.
Tomorrow make a
Serial number-
submission. All cases are being repeated tomorrow, right? Nothing. Yes.